And I have my... Is that? Hang on, what is going on here? What is going on? Here's my Idaho stuff. All right, good over here, Idaho stuff. All right, so we have some new documents that were released, and everybody's abuzz about them. Let me go over here. Okay, so hi easily distracted, hi Debbie 2 Scooter, hi Gail. What is, oh, I'm not in live chat. Okay, and I tried to fix it so you can say hello. Hi the Philly Farmhouse. All right, so let's get to it. We have a bunch of new documents that came out, and we can hand them right here. Get rid of that. All right, so let's look at first this one. Okay, so this one, let me pull this one across here. So this one, let me make this as big as possible for you. State of Idaho versus Bryan Kohberger. This is the redacted state's motion in limine regarding the text messages and the testimony. So it comes now the state of Idaho and through the Latah County prosecuting attorney and respectfully moves the court for an order in limine allowing the state to admit the text messages of DM, which is Dylan, on November 13th, 2022, and the testimony from DM and BF, Bethany, the other roommate, regarding their conversations with each other on November 13th, 2022. The phone records were discovered on the hard drive during Dylan's iPhone extraction from April 5th of 2023, and states Exhibit 18 from the grand jury record, or 8, there it says S1, okay. All right, so let's see, they're going to put the standard of admissibility, but we want to get to the text messages, right? Here's the argument that Dylan's phone records contained in Exhibit S1, bless you, for November 13th, and Bethany's testimony contained in Exhibit S2 as to what Dylan told her should be allowed at trial. In the case at bar, starting on November 13th, Dylan sends a text message to E.G., the Uber driver, to inquire if he is driving. The state submits this text message exchange as not hearsay because it will not be offered for the truth of the matter asserted in E.G.'s driving status. Instead, it would be offered to show a timeline for the night. That Dylan was awake and texting at 2:10. From 4:19 to 4:21, Dylan attempts to call the roommate, Bethany, and she attempts to call Zaina, and she attempts to call Kaylee, and she attempts to call Madison. All calls went unanswered. The records of these calls are not hearsay. Each do not meet the definition of a statement, oral assertion, written assertion, or nonverbal conduct intended as an assertion. Okay, so from 4:22 to 4:24, Dylan and Bethany send the following text messages. So Dylan says to Bethany, "No one is answering." Dylan says again to Bethany, "I'm really confused." RN. Then Dylan texts Kaylee, "What's going on?" She sends Kaylee first, "What's going on?" Then Bethany texts Dylan, "Ya dude, WTF." And Bethany says to Dylan, Zaina was wearing all black. And then Dylan says to Bethany, I'm freaking out, RN. Dylan says to Bethany, no, it's like a ski mask almost. Bethany says to Dylan, STFU. You know what that is, right? Shut the F up. Let me make sure. I want to just make sure that I'm live and you can hear me. You can hear me? You can hear me. Good? Okay. And then Bethany says to Dylan, actually? Dylan says to Bethany, like he had something over his head and little end mouth for head and little ND mouth. Dylan says to Bethany, Bethany, I'm not kidding. I am so freaked out. Bethany says to Dylan, so am I. Dylan says to Bethany, my phone is going to die. F. UCK. Then Bethany says to Dylan, come to my room. And then Bethany says to Dylan, run. And Bethany says to Dylan, down here. All of the above declarations are present sense impressions and excited utterances. This is supported by Dylan's grand jury testimony where she indicates she just witnessed a startling event, i.e., heard noises in the residence and saw an unknown male in the residence. The declarations include both Bethany and Dylan are trying to make sense of the startling event, contemporaneously or immediately following the startling event, i.e., no time for reflection or fabrication. See Dylan's grand jury testimony attached as Exhibit S3. At 4:24:39, Dylan calls Ethan Chapin. The call is unanswered. This phone record, like the other record of calls, is not a statement pursuant to IRE 801A. Dylan and Bethany continue to text at 4:24. Dylan texts Bethany, I'm scared, though, and Bethany responds at 4:25, yeah, I know, but it's better than being alone. Again, both statements are admissible as present sense impressions and excited utterances as they are describing an event or their state of mind and are spontaneous reactions to the event rather than the result of reflective thought. At 4:27:47, Dylan calls Gonsalves. The call goes unanswered. And at 4:28, Dylan calls Kernoodle. Call goes unanswered. These are not statements pursuant to IRE 801A. At 4:32:57, Dylan sends a text message to Kaylee Gonsalves stating, please answer. This statement is a present sense impression showing Dylan's perception of events and an excited utterance, a spontaneous reaction to that event, rather than the result of reflective thought. The next morning, Dylan sends the following text messages starting at 10:23. Dylan to Gonsalves, please answer. Dylan to Mogan, are you up? Dylan to Gonsalves, are you up? These text messages are not hearsay because they will not be introduced for the truth of the matter asserted. Even if deemed hearsay, they're allowable at present sense impressions as they reflect a consistency and continuation of Dylan's text messages from the night prior and reflect her then perception of what was then occurring, i.e., waking up and realizing that she had not heard from her roommates. Why are they even discussing whether this would be, why wouldn't this be admissible? Why wouldn't their text messages be admissible? That's crazy. Okay. At 11:39, Dylan has a text exchange with her father, BM. That's terrible. These statements are not hearsay as they will be introduced for the truth of the matter asserted, but instead to show a timeline for the morning. At 11:50, Dylan receives a text message from Jay stating, "Bro, this text message will not be introduced for the truth of the matter asserted." At 11:50, Dylan calls EA. The phone record is not a statement pursuant to IRA 801A. Dylan receives a text message from Jay at 11:51 and a vandal alert at 1:04. These texts are not hearsay because they will not be introduced for the truth of the matter and asserted, but instead to show a timeline for the morning. The state anticipates that both DM and BF, Dylan and Bethany, will testify at trial. The state intends to ask each witness about statements made to them on November 13th, 2022. The testimony should substantively replicate the testimony they provided at the grand jury proceedings. The state submits the statements from both Dylan and Bethany to each other are allowable hearsay because they are present sense impressions and or excited utterances. Previous adjudication. John Judge has previously ruled that the text messages and statements of Dylan and to Bethany are present sense impressions and excited utterances, holding both the text messages and the testimony of Bethany as to what Dylan told her were admissible as exceptions to the hearsay rule. Sealed order denying motion to dismiss. Indictment on the grounds of biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct. Pages 20, filed on December 15, 2023. Dylan's phone records contained in Exhibit S1 and Bethany's testimony contained in Exhibit S2 are allowable at trial under Crawford. Under IRE 803, present sense impressions and excited utterances are admissible whether or not the declarant is available as a witness. Any statement found outside of the above exceptions to hearsay are non-testimonial for purposes of a Crawford analysis. Further, even if somehow deemed testimonial, the Confrontation Clause of the Sixth Amendment does not bar their admission. Okay, conclusion. Based on the cited authority, the state respectfully requests the court's approval in limine of the admission of text messages from Dylan and the testimony from Bethany regarding what Dylan told her on November 13th. Okay, so that, let's see here. Those are the exhibits. Now let me see what else we have. We have quite a few things here. So there's their text messages. We can go and look at them now just as the text messages. So Dylan is hold on, let me go up here. What does it tell us that? It looks like there's something missing because she says no one is answering. So there's got to be more text prior to this, right? I'm really confused. And then she calls Kaylee and says, Kaylee, what's going on? Then Bethany goes to Dylan, ya dude, WTF. Bethany says Xana was wearing all black. So that makes it seem like she told her. Now, whether she called her and told her she saw a guy all in black, that's just not here. Dylan says to Bethany, I'm freaking out, RN. And Dylan says to Bethany, no, it's like a ski mask almost. And then Bethany says to Dylan, STFU. Bethany says to Dylan, actually. Dylan says to Bethany like he had something over his forehead. See, she's got it all, something over his, I would think it's his head and little and mouth. Dylan says to Bethany, I'm not kidding, I'm so freaked out. Bethany says to Dylan, so am I. Dylan says to Bethany, my phone is going to die, F-U-C-K. Bethany says to Dylan, come to my room. Bethany says to Dylan, run. Bethany says to Dylan, down here. Then Dylan calls Ethan, no answer. She calls Kaylee, no answer. She calls Zaina, no answer. And then Dylan texts Kaylee at 10 in the morning, please answer. She texts Madison, are you up? And then she again to Kaylee, are you up? And of course, no answer. And then she has a text exchange with her father, Dylan does. Okay, and they don't give us the examples of that. So let's go to the next things. Okay, here's something else that was released. This is the motion in limine number 12, the make and model of the suspect vehicle. And this has some pictures that people are sharing right here where you're seeing the car. Let's see. So comes now Bryan Kohberger, and through his attorneys of record, and hereby moves this honorable court to exclude at trial testimony by any state witness as to the make and model of the vehicle seen on the 1112 King Road surveillance footage. The motion is made pursuant to IRE 103, 104, 401, 402, 403, and 702, and further based upon Mr. Kohberger's rights under the United States Constitution, 5th, 6th, and 14th Amendments, and Article 1, Section 13 of the Idaho Constitution. Pursuant to IRE 103 and 104, the court is required, to the extent possible, to limit a jury's exposure to inadmissible evidence. The state has claimed in various filings and reports that an FBI examiner, Anthony Emel, identified the make and model of this vehicle seen driving in the area of 1122 King Road in the early morning hours of November 13th. The state has referred to this as suspect vehicle 1. The vehicle was not identified from surveillance footage in the area of 1122 King Road. Okay, so here's let me make this big for you, as big as I can. So here's the vehicle right there that they're talking about. That is 3:56 a.m. right there. Okay. And it's saying that's the surveillance footage. It comes from a residence on 1112 King Road. It depicts the corner of King and Queen Roads and to the house with the camera. From the footage, lights from vehicles can be seen on Valenta Road, a north-south roadway next to the neighborhood. Okay. And this is 420. These photos are from the 1112 King Road camera. Special Agent Emel did not make a vehicle identification, was not made from this footage. Rather, as noted in emails between Mr. Emel and FBI Special Agent Edward Jacobson, it is clear that the identification of the make and model of the vehicle in this video was made via a separate video taken at 1125 Ridge Road. So, okay. Here's the email, and it's from Edward Jacobson to Anthony Emel, and it says regarding the 451 Paradise Stills 1125 Ridge Road screenshot, says, got a great one, Ed Jacobson. There is no continuous footage linking the vehicle at 1112 King Road footage and that from Ridge Road. Additional surveillance footage depicts vehicles but not identifiable vehicles, thus labeling the cars from various bits of footage as the same vehicle is speculative. Mr. Kohberger seeks an order prohibiting the state linking the vehicle identification of the make and model of the vehicle in the 1112 King Road video based on identification of a car at 1125 Ridge Road and referring to the vehicles as suspect vehicle 1. The speculative nature of testifying that the vehicle is the same vehicle renders it irrelevant to these proceedings, far more unfairly prejudicial than probative. This is also a jury question, and testimony calling the two vehicles the same invades the province of the jury. Thus, the court should exclude the testimony linking the two vehicles as the same. Okay, so do you catch what's going on here? So this footage right here is from 1112 King Road. This footage over here, they're saying is from 1125, which, hold on a moment. They both got to be from 1125 because that's exactly the same. What does it say? These photos are from the 112 King Road. So those are both from, this is both the same exact view. You have this with the pumpkins and this with the pumpkins. So these both have to be from 1112. So they're not showing us the one from 1115 or 1125. The labeling the cars from various bits of footage as the same vehicle is speculative. Based on the identification of the car at 1125. Well, these are from 1112, it says. So they're not showing us 1125. Okay. But they're saying that he made the... Okay, let's see here now. We did the text. Self-authentication, suspect, vehicle. Okay, so we did the text messages, testimony. We did that, right? So we're going to do the let me see this one. Okay, we need to do this one. And let me make sure you're all with me, okay? Are you all with me still? From what I think, let's see. Hi, Monroe. I'm curious if either one of them had their door locked and the others didn't. Maybe he did push on the... I don't know. Yeah, I don't know. Yeah, they did meet up in the house if she saw the ski mask. He must have went by her. Okay. So this now is state's motion in limine for the self-authentication of records in reliance on IRE, yada, yada, yada. Okay, so let's see. So here's, it is listing the state's motions. They are talking about the Albertson, Clarkston, Washington video surveillance, Amazon financial and user records, Bank of America, Bagel Shop video surveillance from November 13th, AT&T phone records for Bryan Kohberger, Madison Mogan, and Xana Kernodle. AT&T, we got that. Let's see, Banner banking records for Ethan Chapin, Cafe, Artesa. Hi, Living Inventory County, how are you? Surveillance video, Corner Club video surveillance, Corner Club financial transaction receipts, Costco from Clarkston, Washington surveillance video, DeSales student records regarding Bryan Kohberger, Dick's Sporting Goods, record of sale for Bryan Kohberger, Discover financial records for Kaylee Gonsalves, DoorDash receipt for Xana Kernodle and Ethan Chapin, early warning records, Elon financial records for Kaylee Gonsalves, ENS services, surveillance video for November 13th, Farmers Insurance surveillance video, Floyd's Cannabis Company surveillance video, ForestDaxCrypto.com financial records for Bryan Kohberger, Grub Truck video surveillance for November 13th, Harbor Freight business and surveillance records, Idaho Central Credit Union bank records for Madison Mogan, Indian Mountain Lake surveillance and records, Joanne's Fabrics financial records, Latta County Sheriff's Office, Deputy Darren Duke body-worn camera, Latta County Sheriff's Office citation issued August 21st, Marshall's financial records for Bryan Kohberger, National Weather Service records for November 12th and 13th, 2022, Numerica bank records for Kaylee Gonsalves, PayPal Venmo financial records, PNC bank records for Bryan Kohberger, Pentel data records, Pennsylvania State Employees Credit Union for Bryan Kohberger, Petco financial records for Kaylee Gonsalves, Rite Aid financial records, Ross financial records, Sunset Mart, Main Street, Moscow surveillance video, Sunset Mart, Pullman, Washington surveillance, Target financial records, TikTok user records for Xana Kernodle, TJX financial records for Dylan, T-Mobile phone records for Kaylee and Dylan, Umpqua bank records for Dylan, Under Armour transaction records for Bryan Kohberger, U.S. Chef Store video surveillance for November 13th, Ulta financial records, Verizon, if I remember that Chef Store is that one that got him in the parking lot or something when he took that drive. Okay. Ulta financial records, Verizon phone records for Ethan Chapin, Bethany and JD, Walmart surveillance and financial transactions for Bryan Kohberger, Washington Department of Motor Vehicles surveillance video from November 18th, Washington Department of Motor Vehicle registration documents for Bryan Kohberger, Washington Trust bank records for Bryan Kohberger, Wells Fargo bank records for Madison Mogan, Winco financial records for Bryan Kohberger, Winco financial records and video surveillance for Bethany and Dylan, Kaylee Gonsalves, Madison Mogan, and Xana Kernodle, Washington State University video surveillance for November 13th, Washington State University parking records. The state relies on IRE 803-24, other exceptions, The state intends to obtain certifications of the above listed items prior to the April 21st, 2025 exhibit deadline. This filing hereby provides notice of the state's intent to introduce and rely on certain evidence as required under IRE 803-6 and 8, IRE 902, 4 and 11, and or IRE 803-24, and the state respectfully moves for orders in limine admitting these records as self-authenticated and or exceptions to the hearsay rule, respectfully submitted the 24th of February. So this is all stuff they want to use as evidence in their case. So a lot of that surveillance and stuff, obviously, to prove their case there. So let's see what else now we have. This next, and okay. All right, so we're going to look at the 911 call, transcript of that. Okay. So this is the sealed, the redacted, used to be sealed state's motion in limine of the 911 call. So it says the 911 recording was discovered and the transcript was discovered as Bates and the number. The facts pertinent to this issue raised by this motion can be found in the attached excerpts from the grand jury testimony. The statements on the 911 call are hearsay but fall within the firmly rooted hearsay exceptions and should be allowed. In general, testimony that is hearsay is excludable at trial. However, there are many exceptions to this rule. Two firmly rooted exceptions are the Idaho Rule of Evidence 8031, where present sense impression and a statement describing or explaining an event or condition made while or immediately after the declarant perceived it, or the Idaho Rule of Evidence 8032, excited utterance, a statement related to a startling event or condition made while the declarant was under the stress of excitement that it caused. The requirements of the federal version of each of these rules are best stated in U.S. versus Mitchell. Okay, so this is their argument here. We want to see this. So let's see what we have here. Phone call made within approximately 1/2 hour of last lewd act were admissible under excited utterance exception by hearsay rule. The victim was in obvious distress, and a lapse of time was not so great as to render exception inapplicable. In the case at bar, most of the declarations made were present sense impressions. H.J. located the unresponsive body of Xana Kernodle and informed Bethany and Dylan to call 911. E.A. was present at the time. All declarants personally perceived the event being, i.e., Kernodle unresponsive. The majority of the declarations were describing to the dispatcher, Carolina Calvin, what they were perceiving, i.e., present sense impressions. Those statements related to Kernodle being passed out and not waking up. The declarations were made immediately after H.J. discovered Kernodle's body. Some declarations made would also be considered excited utterances. Those statements include, "Oh, and they saw some man in their house last night. Yeah," as well as the heavy breathing and crying that can be heard throughout the call. The declarants were responding to a startling occasion, the discovery of an unresponsive roommate. The statement regarding a person being in the home is in direct response to why Kernodle might be passed out. All statements are made while the declarants are processing what is happening, and were made before an opportunity to reflect and fabricate why Kernodle is unconscious. Clearly, the statements of Bethany, Dylan, E.A., and H.J., and the dispatcher, Carolina Calvin, fall within the hearsay rule exceptions. Judge John Judge has already ruled the 911 call is not hearsay, i.e., not offered for the truth of the matter asserted, and even if deemed hearsay, the exception for present sense impression and excited utterance apply. On August 23, 2023, the defendant moved to dismiss the grand jury indictment. One basis for the motion was that the 911 call was improperly admitted. Hearsay, cumulative, irrelevant, and an improper attempt to bolster witness testimony. In response, Judge John Judge held as follows. Further, even if the 911 call is hearsay, the exceptions for present sense impression and excited utterance apply. As the statements made by the callers, i.e. the surviving roommates H.J. and another friend who had arrived, were made immediately after H.J. discovered Ms. Kernodle's body and instructed the roommates to call 911. The rationale justifying the present sense impression exception is that the immediacy of the statement offers no opportunity for fabrication. Finding statements made were excited utterances because the victim was still under the stress of the event. Sealed order denying the motion to dismiss the indictment on grounds of biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct. Regarding the emotion in the callers' voices, Judge Judge further held that the evidence was relevant as to why law enforcement was sent to 1122 King Road on November 13, 2022, as opposed to just EMS when the call was for an unconscious individual. The testimony was deemed relevant to the effect it had on dispatcher Calvin and was not cumulative of Officer Noon's testimony. The statements made on the 911 call are admissible regardless of whether or not witnesses testify. Any statement found outside of the above exceptions to hearsay are non-testimonial for purposes of the Crawford analysis. Further, even if somehow deemed testimonial, the Confrontation Clause of the Sixth Amendment does not bar their admission. Finally, we reiterate that when the declarant appears for cross-examination at trial, the Confrontation Clause places no constraints at all on the use of his prior testimonial statements. It is therefore irrelevant that the reliability of some out-of-court statements cannot be replicated, even if the declarant testifies to the same matters in court. The clause does not bar admission of a statement so long as the declarant is present at trial to defend or explain it. The state submits if any of the declarations made are deemed testimonial, each of the declarants will testify at trial. Okay, so here's the call. The dispatcher says 911 location of your emergency. A woman says, "Hi, something is happening. Something happened in our house. We don't know what. We have," the dispatcher says, "what is the address of the emergency?" The woman says 1122. "No, don't." The dispatcher said, "What is the rest of the address?" She says, the woman, "Oh, Kings Road." "Okay," the dispatcher said, "and is that a house or an apartment?" The woman says it's a house. The dispatcher says, "Can you repeat the address to make sure that I have it right?" Now another woman identified as A1, woman 1, says, "I'll talk to you guys. We live at the right, so we're next to them." The dispatcher says, "I need someone to repeat the address for verification." Woman 1 says, the address 1122 King Road. The dispatcher says, "And what's the phone number you're calling from?" And the woman says, "What's your phone number?" And then that's redacted about the phone number. Then the dispatcher says, "Okay, and tell me what's going on." Woman 1 says, one of the roommates who's passed out, and she was drunk last night and she's not waking up." And then the other woman says, "No, we saw." The dispatcher says, "Okay." Woman 1 says, "Oh, and they saw some man in their house last night." "Yeah." Then the woman says, "Hi." The dispatcher says, "And are you with the patient?" "Okay, I need someone to keep the phone. Stop passing it around," the dispatcher says. The first woman that was on said, "Can I just tell you what happened pretty much?" The dispatcher says, "What is going on currently? Is someone passed out right now?" The woman says, "I don't really know, but pretty much at 4 a.m. The dispatcher says, "Okay, I need to know what's going on right now. If someone is passed out, can you find that out?" The woman says, "Yeah, I'll come. Come on. We gotta go check. But we have to. Is she passed out?" "She's passed out. What's wrong?" The dispatcher says, "Dispatching the Moscow Law Ambulance for..." The woman says she's not waking up. The dispatcher says, "Unconscious, 1122 King Road." And then, let's see, who's this? Another dispatcher? Let me see. Okay, a man. Q1 is just a man. So I think he's still in dispatch. And he says 70 is en route. And then the dispatcher says, "Okay, one moment. I'm getting help started that way." The other woman that called first says, "Okay, maybe." Then the dispatcher says 1122 King Road. All ambulance respond for unconscious 1122 King Road. Another dispatcher says, I copy. That dispatcher says 58, multiple RPs on the phone. Advised saying the roommate on scene is passed out and not waking up. Believes she got drunk last night and unintelligible about a male being in the room with them. Then the dispatcher says unintelligible being around. The dispatcher says that one I copy about a 20-year-old female unconscious trying to get further. Q1 says copy. Then the other woman says, yeah, it's Evan. Okay, A2, I'm sorry. A2 is a man. So, okay, man, sorry, not another woman. Where did we go? Yeah, it's Evan. Okay, says the woman. Then the dispatcher says, okay, and how old is she? The woman says, she's 20. The dispatcher says, 20, you said. The woman says, yes, 20. Here, do you want to talk to him? Okay, the dispatcher says. Now, A2 is the guy. Says, hello. The dispatcher says, okay, I need someone to stop passing the phone around because I've talked to 4 different people. Then the man says, okay, sorry, they just gave me the phone. The dispatcher says, is she breathing? The man says, hello? The dispatcher said, is she breathing? The man says, no. The dispatcher says, okay. The other dispatcher says, en route. The man says, Bethany or Dylan, I need you to talking to them, okay? I can't talk to them. I need you to talk to them. The woman says, okay, hello. The dispatcher says, okay, I have already sent the ambulance and law enforcement. Stay on the line. The woman says, okay. The dispatcher says, is there a defibrillator available? Send someone to get it now and tell me when you have it. Units responding. RPs advising. The woman says something unintelligible. The dispatcher said the patient is not conscious and not breathing. The woman says something unintelligible. The dispatcher says, okay, if there is a defibrillator available and someone to go get it now and tell me when you have it. The woman answers, we don't have one. Then one of the dispatcher says, unconscious, not breathing. The woman says, do you have a defibrillator? The dispatcher says, yep. Then the woman says, yes, we have one. And then the dispatcher says, but are you talking to the officer? The woman says, yes. The dispatcher says, okay, I'm going to let you go since he's there with you and can help you. And then the woman says, okay, thank you, bye. The dispatcher says, okay. Another dispatcher says, Moscow, 46 out. Another one says, copy. Another one says, 13. I think we have a homicide. Moscow, engine 20 is en route. 1370. 70 unintelligible. 1071 related. Okay, that's the 911 call. Now let me see where you guys are. Hi, Captain Lee fan. Hi, Cranky Babishka. Good to see you. Okay, so did you guys get all that? Is this the transcript of... Yes, that's the transcript of the 911 call. Yes, it is. Yes, it is. It looks like... I don't understand something. Wasn't Xana found in the same room as Ethan? I thought they were in the same room. How come they're only mentioning Xana? Is that strange? And they're not mentioning blood. And they're not mentioning Ethan. And they're only mentioning Xana. So where is Ethan? And they're not mentioning blood, right? They thought she had been drinking and was passed out. That is strange, isn't it? I thought they were in the same room. I actually thought that you saw Ethan first because I thought he was closer to the one side of the bed when you walked in, and I thought Zaina was on the far side of the room, like by the window. Maybe they were freaking out. I know I would be. Yeah, I don't know. It's just strange. Weird. Okay, let's see what else we learn. They were talking to how easily distracted. They were talking to who? They said that Zaina was not responding at all. Okay. Let's see. All right. Let's see what this one is. We got 911 call. Okay, let's look at this one now. This is the defendant's motion to preclude the death penalty and adopt other necessary procedures due to the state's numerous disclosure violations. Comes now Bryan Kohberger, Bryan through his attorneys of record, and respectfully requests that this court remedy the state's failure to comply with its obligations under the state and federal constitution, state law, the rules of the Supreme Court of Idaho, and the scheduling order of this court. The state has failed to provide expert disclosures that are specific enough to understand what testimony and discovery it intends to rely on, depriving Mr. Kohberger of the ability to conduct independent review and investigation of the evidence it will rely on. Additionally, as counsel has previously stated, the discovery in this case has been provided in a manner that is as though the state took tens of thousands of documents, photos, and video clips, shook them up in a snow globe. While defense counsel has been made Herculean efforts to review the discovery provided, there is no possible way all of the discovery, which is equivalent to 68,000 copies of the Encyclopedia Britannica, can be reviewed prior to the trial date. Indeed, a defense expert informed counsel it would require 3 additional years to review all of the discovery from the 67 electronic devices and digital data alone. By providing discovery in this manner, the state is failing to comply with their obligations under Brady v. Maryland. It says these cases require the prosecution to provide exculpatory and impeaching information to the defense, including any information that would tend to mitigate the punishment, even if it's not constitutionally material, in a manner and time frame that it could be reasonably relied upon in preparing for trial. As discussed in this motion, in cases with enormous amounts of electronic data, the prosecution does not meet that standard by providing discovery in a manner that effectively varies exculpatory, impeachable, and mitigation information. Timely and meaningful disclosure is indispensable to the effectuation of the right to a fair trial, due process, effective assistance of counsel, and the right to be free from cruel and unusual punishment pursuant to the 6th, 8th, and 14th Amendments to the U.S. Constitution and Sections 6 and 13 of Article 1 of the Constitution of the State of Idaho. A single Encyclopedia Britannica contains more than 30 volumes. Mr. Kohberger requests that the court exclude evidence and testimony that the state has not yet provided in adequate expert disclosures and accompanying motion in limine has been filed regarding the specifics of the evidence. The details are not repeated herein, but incorporated by reference. Exclusion of that evidence, however, is insufficient to cure the whole of the prejudice to Mr. Kohberger. Like other trial courts around the country, the court must also order the prosecution to provide a detailed index of documents it intends to rely on, as well as an index of the Brady information, and preclude the death penalty at the upcoming trial in order to meet the constitutional standards of due process and a fair trial. Mr. Kohberger acknowledges this motion requests preclusion of the death penalty as one of the remedies after this court's ordered deadline. However, good cause exists for this filing. The state has produced an enormous amount of disorganized data, continues to provide discovery past their deadline, refuses to provide requested supplemental discovery, and has failed to abide by expert disclosure rule and order. Okay. Mr. Kohberger has litigated the state's identification of him through its IGG investigation. Multiple discovery requests, motions to compel have been heard. During his motion to suppress, Mr. Kohberger learned that new information relating to procedures and protocol, laboratory information about its work, and additional investigation that took place. He promptly requested that the same through discovery. His request resulted in the state acknowledging it withheld information sought and a refusal to provide it. The state further promised some discovery which has not yet arrived, but overall said Mr. Kohberger was too late to get the information. Mr. Kohberger has filed a motion in limine to exclude IGG. Those arguments are incorporated but not repeated herein. Hold on, I've just got to put my phone on the charger for 1 second because it's going to die, and then when I need it later on, I'm not going to have it. So just give me 1 second. Okay. Happy birthday to Evie. She's out partying, but happy birthday, Evie. Okay. Let me go over here. Back again. I just had to put that on the charger. So where were we now? During his motion to suppress, Mr. Kohberger learned new information relating to procedures, protocol, laboratory information about its work. We got there. Okay. He promptly requested the same through discovery. His request resulted in the state acknowledging it withheld information sought and a refusal to provide it. The state further promised some discovery which has not yet arrived, but overall said Mr. Kohberger was too late to get the information. Mr. Kohberger has filed a motion in limine to exclude IGG. Those arguments are incorporated but not repeated herein. Okay, mitigating evidence is material when it may well have been consequential to the jury's deliberations on punishment. Yada, yada, yada. Okay, relevant, let's do this. Relevant factual background. Mr. Kohberger has consistently demanded that the prosecution comply with its obligations under the state and federal constitutions to provide exculpatory and impeaching information to the defense, as well as any information that would tend to mitigate the punishment. The defense has filed more than 20 supplemental requests for discovery, specifying evidence the state has failed to turn over. The state has turned over more than 68 terabytes of data. That much data is the equivalent of 68,000 copies of the Encyclopedia Britannica. Okay, and it goes on about this. The discovery that has been provided includes more than 13,000 photographs, more than 15,000 video clips from businesses, and more than 8,000 video clips from residences. It also includes more than 60 plus digital devices and digital data and search warrant data, including cell phones and laptops from Mr. Kohberger, the victims, alternate suspects, and various other individuals who knew the victims. While the state has had access to many dozens or even hundreds of detectives and investigators from multiple law enforcement agencies, including the FBI, in addition to the use of expensive AI and technological programs to facilitate production and review of this massive amount of discovery, the defense team consists of 3 attorneys, a mitigation specialist, and 3 investigators. There is no way, even though the greatest of due diligence, that the defense can independently review all of this discovery. In providing discovery, the state has not provided it in a searchable format and has not provided detailed logs and indexes that would facilitate the defense's review of the evidence, and has not provided an index of Brady evidence or evidence that may be relevant to the defense. Additionally, the court set an expert disclosure deadline that passed more than 1 month ago. While the defense complied, the state provided vague disclosures that failed to identify opinions that experts would provide or detail the facts and evidence that they would rely on for those opinions. For example, the state's expert disclosure listed 3 alleged experts who would testify relating to the 67 electronic devices, digital data, and search warrant return data as provided in discovery. The scope of that evidence is so broad that a defense expert estimated it would take more than 3 years to review. The state did not identify any actual opinions it intends to elicit about these devices and failed to identify any portions of the data that would be presented or relied upon. While after the disclosure deadline, the state turned over a report stating that examinations of the devices are ongoing, which only heightens the prejudice to Mr. Kohberger and further depletes his time to conduct any independent review or evaluation of the state's evidence. This is only one of many disclosures in which the state failed to identify what opinion the expert would testify to and failed to point to specific evidence or discovery that would be relied upon. Moreover, even after this, court told the state that the job was not done with its expert disclosures, the state produced a circular argument blaming the defense in its rebuttal disclosures about the electronics and digital data and third-party warrants. No additional opinions, clarifications, or specifics were provided, and finally Mr. Kohberger requested additional discovery related to IgG after he learned of its existence for the first time in his motion to suppress. The state acknowledged it had undisclosed information but refused in part to provide it and promised in part to provide some information. No discovery has not been disclosed. See also Mr. Kohberger's motion in limine to exclude IgG. As discussed below, the state has gained a tactile advantage that cannot be remedied now, and therefore this court must take affirmative steps to put Mr. Kohberger back on equal ground. The prosecution's, this is their argument, discovery obligations under the federal and Idaho constitutions and Idaho law. Both the federal and Idaho constitutions, as well as Idaho law, require that the prosecution turn over any materials to the defense which may help the accused either by negating the guilt, mitigating punishment, or impeaching the state's witnesses. The prosecution has a constitutional duty to identify, preserve, and disclose exculpatory information. Under the Due Process Clause of the 14th Amendment to the U.S. Constitution and Article 113 of the Idaho Constitution, criminal defendants are entitled to proceedings that comport with prevailing notions of fundamental fairness. These notions of fundamental fairness require that a defendant be provided with evidence favorable to the defense. Accordingly, the state violates a defendant's due process rights whenever the state suppresses evidence that is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. The prosecutor's duty to produce this material is self-executing. She must turn over Brady material regardless of whether the defense has made a specific request. The good faith or bad faith of the prosecutor is not relevant to the Brady inquiry. Whether the non-disclosure was a result of negligence or design, it is the responsibility of the prosecutor. The prosecutor's office is an entity, and as such, it is the spokesman for the government. The duty exists even if the defense conceivably might have access to the information independently. Non-disclosure of government witness paid informant status not absolved even if the defendant might have uncovered it through independent sources, tapes disclosed to the co-defendant, not effectively disclosed to the defendant because trial strategies of co-defendants often conflict. To comply with their constitutional obligations, the state must disclose exculpatory evidence in time for its effective use at trial. When the state fails to produce exculpatory evidence in time for its use at trial, the state has suppressed the evidence in violation of a defendant's due process rights. Additionally, when exculpatory materials have been disclosed too late for their effective use at a trial, they ultimately disclosure implicates a defendant's constitutional right to the effective assistance of counsel under the Sixth Amendment to the U.S. Constitution and Article 113 of the Idaho Constitution. The right to the timely disclosure of favorable evidence guarantees an accused sufficient time to investigate and evaluate the evidence in preparation for trial. In addition to allowing for full investigation, which could lead to more favorable or exonerating evidence, the timely disclosure of Brady material can alert defendants to viable pretrial challenges, such as the suppression of evidence. Idaho Criminal Rules 16A, the Idaho Rules of Professional Conduct, the ABA Rules of Professional Conduct, and Brady progeny all require timely disclosure of discovery materials, meaning prosecutors must turn over information at the earliest feasible opportunity. In death penalty cases, Brady includes information that may not exculpate, but that nonetheless mitigates punishment. As such, even when evidence is not probative at all regarding a defendant's guilt or innocence, or even when the evidence is more likely to support a finding of guilt during the last phase of a capital trial, the evidence may still be Brady material if it could lead to a lesser punishment, as the Supreme Court has emphasized, while evidence that is material to guilt will often be material for sentencing purposes as well. Okay, and then, where was I? Okay, sorry, I had a note coming through. Let's see where I was. As the Supreme Court has emphasized, while evidence that is material to guilt will often be material for sentencing purposes as well, the converse is not always true. As such, when the state has elected to seek the death penalty, the Supreme Court has required a lesser showing of materiality to establish a Brady violation. A sentence will be reversed when the cumulative impact of the evidence may well have been material to the jury's sentencing decision. Okay. Let's see here. The obligation to disclose exculpatory evidence extends beyond what the prosecutors are personally aware of and beyond four walls of a prosecutor's office. It applies to federal law enforcement officers, state lab technicians, and other state actors. The prosecution's obligation to preserve and disclose exculpatory evidence does not turn on whether the prosecutor knows of the evidence. The duty of disclosure enunciated in Brady is an obligation of not just the individual prosecutor assigned to the case, but of all the government agents having a significant role in investigating and prosecuting the offense. Thus, the prosecutor is constitutionally obligated to actively investigate and preserve potentially exculpatory evidence. The prosecution may not be excused from disclosing what it does not know, but could have learned. Additionally, the prosecution may not delegate the job of determining what evidence must be turned over to the defense, but instead must affirmatively seek out all relevant information from everyone involved in an investigation. Therefore, a prosecutor will not be excused for failing to turn over information that was known to the police. Given this obligation, it is obvious that Brady extends well beyond the four walls of the prosecutor's office. Because Brady does not require bad faith on the part of the prosecution, the state's obligation is an affirmative duty to learn of and then to disclose exculpatory evidence in the custody of other members of the prosecution team, as well as any other state actors involved in this case. Therefore, a prosecutor's Brady obligation extends to exculpatory information obtained or possessed by any federal or investigative agency with involvement in a case. What? Including the Federal Bureau of Investigation. Okay. Let's see where we are. It's so windy out. Let's see here. What's going on here? Okay, the Idaho criminal rule for the timely disclosure. So mainly what they're saying is there's so much discovery, and the discovery, some of it didn't meet deadlines, and it would take 3 years to review it for a trial. And how can they do this when it's a death penalty case and it's just not right? And now they're saying that even if the prosecution doesn't realize they have the obligation to bring this stuff that any state actor has, they have that obligation, and it's just they're going on and on about how this is never going to be able to be reviewed, how they're never going to get all the stuff they need, and this, may help them. There may be something there about this because it's a death penalty case, right? That they need to review all this, and if they can't do it, then how can you have the death penalty on the table? So that's what this is all leading up to, okay? In addition to a prosecutor's Brady obligations, Idaho Criminal Rule 16A requires the prosecution to disclose as soon as practicable any material or information which tends to negate the guilt of the accused as to the offense charged or reduce the punishment therefor. These obligations extend to any information and material in the possession or control of members of the prosecuting attorney's staff and of any others who have participated in the investigation or evaluation of the case. Okay. Therefore, ICR 16 charges Idaho prosecutors with an affirmative duty to seek out and obtain all exculpatory and mitigating evidence and disclose it to the defendant in a timely manner. The Idaho Rules of Professional Conduct and the ABA Model Rules of Professional Conduct further recognize the prosecutor's ethical duty to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense, and in connection with sentencing, disclose to the defense and to the tribunal all unprivileged mitigating information known to the prosecutor, except when the prosecutor is relieved of this responsibility by a protective order of the tribunal. The ABA criminal discovery standards further reflect a prosecutor's well-settled discovery obligations and admonish the prosecution to turn over any and all information within their control that would 1. Tend to negate the guilt of the defendant, 2. Tend to reduce the punishment of the defendant, and 3. Any material which may be used for impeachment. Further, the prosecution must disclose to the defense when they are aware of information but do not have evidence verifying the information, when it would be discoverable if it were in their possession or control. When exculpatory material is contained in voluminous amounts of electronically stored records, the state violates its Brady obligations by doing nothing more than turning it over unorganized on a drive. Right? Here it is. It's like when they tell you, right, for taxes or something, don't keep everything organized, and then if you get audited, just like throw a whole bunch of stuff out there, right? I'm joking, but that's what it sounds like. Oh, here's the stuff. It's like no index, no nothing. You find it on your own. No. The court ordered prosecution to identify Rule 16 Brady and Giglio documents contained in voluminous discovery production as a matter of case management. Okay. So they're talking about another case here. And then they're saying, in the context of vast electronic records, even the circuit courts that have adopted the most narrow approach to a prosecutor's Brady obligations have held that the government must do more than simply produce the contents of these devices. Okay, so they're talking about another case, United States versus Skilling, that in part was vacated on other grounds. The defendant challenged the government's open file disclosure of several 100 million pages of discovery in an electronic file. So they're citing that case. The state has taken none of the steps beyond more production in this case. The electronic file is not searchable. Defense counsel must locate and click into each and every separate document, of which there are many thousands, to find its contents. The state has not produced an index of the documents that it will rely on in this case. To the contrary, the expert disclosure deadline has come and gone without the state identifying its experts. Conclusions and which documents it will use to support those conclusions. The state has not provided an index of Brady material, including exculpatory and impeachment information, nor an index of documents that are potentially relevant to the defense case. Indeed, the state has not provided anything to assist in the defense's review, despite the knowledge that it would be impossible, even though the exercise of due diligence, to identify exculpatory or impeachment evidence within the hundreds of millions of pages, tens of thousands of photos, and thousands of hours of videotape and audio recordings. Under the more exacting standards adopted by other courts, it is even more plainly apparent that the state's approach to its Brady obligations run afoul of Mr. Kohberger's due process rights. For example, the District of Columbia has rejected the Fifth Circuit standard as too lenient, thereby directing the government to identify exculpatory information within its voluminous production. The above problem is exemplified by, though certainly not limited to, the 67 electronic devices and other digital data and search warrant returns that the state has turned over, since the state has not provided specific reports or indexes of materials it intends to use from the devices, digital data, and search warrant returns. The defense must guess which form electronic reading software is utilized. For most devices, no specific report has been produced. For some devices, Axiom is used, and for some, Cellbrite. The software produces different results for the same device. Each device results in an enormous volume of information to sift through. A single cell phone often produces more than 10,000 pages of material, and this is because modern electronic devices, including cell phones, have the capacity to store vast amounts of highly personal information. Given the capacity for a person's electronic device to effortlessly generate and compile vast amounts of information, searches of these devices typically expose far more than the most exhaustive search of a house. And they may enable the reconstruction of the sum of an individual's private life. For most people, their computers are their most private spaces. People commonly talk about the bedroom as a very private space, yet when they have parties, all the guests, including perfect strangers, are invited to toss their coats on the bed. But if one of those guests is caught exploring the host's computer, that will be his last invitation. It's an interesting argument there, isn't it? Toss their coats on the bed. Okay. All right. I've never asked my guests to toss their coats on the bed. Okay. Yeah. As such, contents of all the 67 electronic devices, digital data, and search warrant returns seized in this case contain enough information to paint a portrait of the daily lives of Mr. Kohberger, the victim's witnesses, alternative suspects, and people close to the victims, given that the state's case is almost entirely circumstantial. Patterns of evidence that emerge out of these devices may be key to the jury's consideration of guilt or innocence. Courts often describe evidence regarding potential alternative perpetrators as classic Brady material. Withholding knowledge of a second suspect conflicts with the Supreme Court's directive that the criminal trial, as distinct from the prosecutor's private deliberations, be preserved as the chosen forum for ascertaining the truth about criminal accusations. Okay, so now they're talking about countless cases have been overturned due to prosecutors' failure to timely produce evidence that could have helped the defense identify a potential alternate perpetrator. And now they're talking about another perpetrator, right? And they're citing cases about that. Let's see here. Because many of these devices belong to the witnesses, the victims, and to the people who knew the victims, including potential alternate perpetrators, defense counsel is plainly obligated to review them. Defense counsel has never subjected the prosecution's case to meaningful adversarial testing. Then there has been a denial of the Sixth Amendment rights that makes the adversary process itself presumptively unreasonable. But the defense cannot reasonably make effective use of voluminous electronic records because the state has not provided them in a detailed or indexed manner. Reviewing and understanding all of the records from these devices, digital data, and search warrant returns alone would require 3 years, even if defense counsel did not look at any of the other discovery. Okay, worse yet, guys. The state apparently intends to rely on this evidence to establish guilt through 3 different experts, but has not identified what opinions these experts have drawn from the evidence, nor which parts of the voluminous data they're relying on. The state has created a situation where the defense is completely in the dark and cannot mount even a limited investigation into rebutting their experts' testimony, including by identifying impeachment evidence or evidence that contradicts their experts' opinions. Rather than cure this deficit when the court told the state that its job was not done with its expert disclosures, the state submitted expert rebuttal disclosures that blame the defense for its inability to properly disclose expert opinions related to electronics, digital data, and search warrant returns. The state's failure to timely disclose the evidence in a meaningful way has prevented Mr. Kohberger from developing a full defense to the allegations in this case, and as a result, the defense will not have the ability to identify the critical pieces of evidence or conduct necessary follow-up investigation on those pieces the state intends to rely on in the merits phase. The failure of the state to identify important documents in the massive electronic data dump, including exculpatory documents, will hamper Mr. Kohberger's ability to meaningfully contest the state's theory. Moreover, the state's failure to identify exculpatory documents relating to the sentencing phase will prevent a capital jury from receiving a complete picture of the life of Mr. Kohberger, supported by electronically generated records. Therefore, by dumping the contents of 67 electronic devices, digital data, and search warrant returns on defense counsel without identifying the pertinent information within them, the state has violated Mr. Kohberger's due process rights and his right to effective assistance of counsel at both the merits phase and at the capital sentencing proceeding, as well as the statutory rights under ICR 16. When the prosecution seeks the death penalty, defense counsel must independently investigate all evidence, whether testimonial, forensic, or otherwise purporting to inculpate the client. In recognizing the large number of individuals sentenced to death who were later exonerated because they were innocent, the importance of defense counsel's duty to take seriously the possibility of the client's innocence, to scrutinize carefully the quality of the state's case, and to investigate and reinvestigate all possible defenses. Thus, a meaningful ability to review discovery and the state's case is essential to the right to a fair trial and effective assistance of counsel in a capital case. This is a case where the facts are in great dispute. Mr. Kohberger asserts his innocence. There is no confession. There is no video or audio of the crime. There is no weapon. There is only trace evidence on a movable object, a knife sheath. Having full knowledge of the state's expert opinions and the documents they will rely on will provide leads for further investigation to uncover exculpatory evidence or to impeach prosecution witnesses. In addition to a complete investigation of every piece of the state's case, counsel is responsible for identifying and considering all legal claims potentially available, even if those claims have consistently lost in that jurisdiction. This is necessary because counsel in a capital case has a duty to preserve any and all conceivable errors for each stage of appellate and post-conviction review, as the non-preservation of an issue at the trial stage may result in a defendant's execution, even if reversible error occurred. In a case as complex as this one, the state's failure to direct the defense to evidence it will rely on in accordance with the court schedule is highly prejudicial. It will undoubtedly impact the defense's ability to meet the evidence at trial, develop a comprehensive defense strategy, adequately respond to each aspect of the state's case, and complete all pretrial litigation about admissibility of the evidence. Even assuming the state discloses details, expert disclosures, and an index of hot documents tomorrow, the counsel will need the remaining months before the trial to conduct independent investigation into the evidence and witnesses, identify evidence that contradicts the state's theories, and incorporate all of the new evidence into the defense's case. it will not be possible to do this to the extent required in a death penalty case, in addition to identifying and preserving all of the related legal claims that could stem from the evidence. Thus, as discussed below, because heightened reliability standards cannot possibly be met on this time frame, the court must preclude the death penalty. The Supreme Court has been clear that the death penalty must be reserved for only those few offenders deemed extraordinarily culpable and therefore uniquely deserving of death. The average murderer is insufficiently culpable to justify the most extreme sanction available to the state. A case is not capital just because it is the worst murder a community has ever seen, nor is it capital because it technically checks the boxes of the necessary aggravating factors under a capital sentencing statute. A case may only appropriately be capital, in the words of the U.S. Supreme Court, when it falls into a very narrow category of the most serious crimes and involves a defendant whose extreme culpability makes the most deserving of execution in the entire country. Heightened constitutional obligations apply in death penalty cases because a life or death sentencing decision is qualitatively different from sentencing decisions involved in any other kind of case. The nature, quality, and gravity of death cases make the defense of capital cases fundamentally unlike any type of legal endeavor. As a result, death penalty trials require especially stringent due process from both the judge and attorneys and may not be treated as standard criminal cases. Courts must go to the extraordinary measures to ensure the death penalty trial is fair. So long as Mr. Kohberger's death is a possible result of this case, the state of Idaho and the court must go to extraordinary measures to protect his constitutional rights. Because the state has failed to satisfy its disclosure obligations in a manner that would enable Mr. Kohberger to further investigate and incorporate exculpatory evidence into his defense for an August 2025 trial, Mr. Kohberger will be deprived of a fair trial and the right to effective assistance of counsel if the court does not remedy this situation. The court has wide discretion to remedy discovery violations as appropriate under the circumstances. When the state has failed to timely produce evidence in violation of the Constitution, the court must choose between barring, furthering prosecution, or suppressing the state's most probative evidence. In past cases, courts have entirely dismissed indictments based on discovery violations to protect the defendant's constitutional rights, to sanction the government for misconduct, and to deter further Brady abuses. Mr. Kohberger is not requesting dismissal of the indictment for these violations, at least at this point, because 5 months remain before trial. The defense believes there are remedies that the court can order short of dismissing the case that will likely remedy a significant amount of the prejudice. 1. Preclude experts and testimony not properly and timely disclosed by the state. Mr. Kohberger requests that the state be prohibited from introducing experts' testimony and underlying evidence that has not been properly detailed in an expert disclosure for which the deadline was January 9th of 2025. Those specifics are detailed in the accompanying motion in limine. Given the compounding prejudice of late disclosure with the extreme amount of discovery has been provided in a format that does not meet the minimum standards the court has considered, see Section 2 supra, Mr. Kohberger respectfully requests that this court orders the state to provide within 2 weeks of the soonest this court deems reasonable a detailed index of the discovery and evidence that they intend to rely on at either the merits phase or in sentencing, and a detailed index of Brady Giglio documents and evidence, including potentially exculpatory or impeachment information. Given the amount of data, the government cannot meet its Brady obligations by providing Mr. Kohberger with access to more than 68 terabytes of data and then claiming that he should have been able to find the exculpatory information in the haystack. Both of these indexes should include Mr. Kohberger's Mr. Kohberger reserves the right to request dismissal if and when the circumstances warrant it. The state's current method of noting the date is it has produced a batch of discovery, and the number associated with the discovery pleading is not a detailed index. Location of the document in a way that makes it identifiable easily by the defense. As discussed above, evidence pointing to a possible alternate perpetrator or anything refuting the state's theory is bedrock. Brady evidence and should be included. Moreover, if this proceeds as a death penalty case, Brady material includes any evidence that would tend to mitigate punishment. Examples of this evidence in a capital case include evidence that a capital defendant was a devoted and loving family member, that he experienced trauma, neglect, isolation, or ostracization as a child, young adult, or adult, that he excelled in his education, that he experienced blows to the head or other potential brain injuries, that he experienced depression, anxiety, or other symptoms of mental illness, that his symptoms began before he was charged with capital murder, and or that he is susceptible to pressure, manipulation, or exploitation. Courts have also precluded the prosecution from seeking the death penalty in would-be capital cases when the prosecution fails to satisfy their pretrial discovery obligations. As the First Circuit has noted, dismissal of the notice to seek death is not as extreme as dismissal of an indictment. The government may still seek a conviction and the serious penalty of life imprisonment. The less, oh my gosh, you scared me, Luke. Why do you come through the door like that?
That's how you open it.
Oh man, that's how you open it? You gave me a heart attack almost. Sorry. The less extreme remedy is appropriate even in situations when the violations would not amount to a sanction in a non-capital felony case. We do believe that in a capital case, when the stakes are so high, a smaller quantum of prejudice may justify a sanction than in a regular murder case. And as discussed above, striking the notice is not quite as serious as dismissing the indictment altogether, and so perhaps still less prejudice is required. Okay, let's see. Oh, I've been feeling that I was having a heart attack all day. Got this like tightness in my chest. I think it's from that cough that I had, and that's like it's hard for me. It feels like especially when I'm talking, I can't get a deep breath, and I've had that since I've had the COVID too. So that's crazy. But let me see what the heck if we're still on here. Wow, he scared the crap out of me. Okay, hi, it's just me. Hi, Mike. Hi, Whisper to me. Hi, Luke. Yeah, scared me. Okay, I startle very easily. Mike says, if we find out Dad turned him in that night on top, the sister was smart. If we find out that Dad turned him in that night, on top. The sister was smart. Okay. Hi, Mike. Okay. So let's, having a bowl of cereal now?
Yeah.
10 or 12. Okay. Another Idaho trial court recently concluded that precluding the death penalty was the only way to cure the prejudice of disclosure violations by the state. Oh, look what they're citing now. Listen to this case. No, I'm talking to them. In Idaho versus Lori Vallow Daybell, the state had Bates stamped and previously provided more than 80,000 documents in discovery. However, the prosecution failed to turn over approximately 5,000 pages of discovery and 30 hours of audio files until a month before trial. The court ruled from the bench and signed an order. This is notably many multitudes less than the 68 terabytes of discovery turned over in this case. Though the prosecution filed the discovery only one day after the deadline set by the court, the defense argued that there was insufficient time for counsel to review the significant discovery in a meaningful manner and, good night, I love you, and complete any necessary follow-up prior to the trial date 1 month later. The court agreed and found that dismissal of the death penalty was appropriate in order to mitigate the prejudice. Because Lori Vallow was supposed to be a death penalty case. They did take it off the table for her. They did not take it off the table for Chad. Then it says, the court specifically found that the state had acted in good faith and attempted to disclose all discovery, and that the remedy was not in any way intended for a sanction to be a sanction for bad faith or misconduct by prosecutors. However, the court specifically noted that death is different. Death is different. The heightened standards of reliability and unique safeguards must apply in a death penalty case, and therefore, striking the death penalty was the only appropriate remedy. This court has commended in other proceedings related, to Mr. Kohberger's trial settings and motions about discovery and expert opinions that Lori Vallow's case is distinguishable because she had not waived her speedy trial rights. However, in this case, it is the court that is repeatedly telling all counsel and Mr. Kohberger that the trial date is set in stone and everyone must be ready to proceed by July 30th of 2025. In another case, a federal district court precluded the government from seeking the death penalty for 2 defendants after the prosecution failed to turn over some of the statements made by a witness for approximately 1 year after the defendants had been arrested. Okay, so it goes on. And yet another case, and they put another one in there, right? Okay. Several other judges have struck the death penalty as a sentencing option in response to disclosure violations as well. And it's going to cite some more cases here. Okay. Mr. Kohberger has repeatedly brought forth facts that demonstrate serious prejudice to his due process rights. He has repeatedly raised the issue of the chaotic and disorganized production of discovery. He has repeatedly compelled discovery, regardless of whether it was purposeful or inadvertent. The prosecution has shirked its responsibility to fulfill its constitutional obligations to provide timely disclosure to the defense. As a result, the defense's ability to investigate has been seriously impeded. Regardless of whether the failure to organize the voluminous discovery into a searchable and usable form, identify potential exculpatory evidence, and provide minimally adequate expert disclosures on the timeline set by this court is intentionally or merely the result of inattention the prejudice is the same. Indeed, other courts have precluded the death penalty on far less, and bad faith is not the standard for applicability of sanctions. Okay, so let's go. Striking the death penalty is the only remedy that begins to adequately address the prejudice to Mr. Kohberger, even with a hot documents list and detailed expert disclosures, the minimum necessary for this case to proceed to trial. Counsel is at a massive disadvantage given the limited resources as compared to the state and the fact that only 5 months remain before trial, and the tactile advantage that the state has gained because the defense compiled with the court's disclosures deadlines cannot, and that the defense complied with the court's disclosures deadline cannot be remedied after the fact. Though counsel could proceed to a non-capital trial by making strategic decisions about what to follow up on in the limited time frame, counsel will not have time to complete the type of investigation that would be necessary to meet the required heightened reliability standard in a death penalty case in light of the late disclosures and mountains of discovery. So they're saying they could, proceed to a regular murder trial where the death penalty is not on the table, even given the limited time frame. But if it's a death penalty case, there is no way they can meet the required heightened reliability standard. Precluding the death penalty is therefore necessary to enforce Mr. Kohberger's constitutional rights. Taking the death penalty off this is the only way. That's what they're saying. This remedy will also reduce the significant risk of seating a conviction-prone jury that does not hold the prosecution to their burden of proof, a fact that would exacerbate the state's already gained strategic and resource advantages. Though a risk will remain that the extensive and prejudicial pretrial publicity will negatively impact the fairness and accuracy of the jury's fact-finding, this risk will be mitigated when it is not compounded by the process of death. Okay. Qualification, a process that skews the jury towards conviction and death during voir dire before a single piece of evidence has been presented. So, yeah, they're saying that's the only way. The only way. Okay, let's see what else. Okay, let me see. Now, this was the autism, the autism spectrum. They said that the court, having before it stipulated motion to file the defendant's exhibits in support of their motion to strike the death penalty, autism spectrum disorder under seal, and good cause appearing now before me, it is hereby ordered the defendant's exhibits in support of their motion to strike the death penalty regarding the autism spectrum disorder shall be filed under seal. So ordered. So order sealing defendant's exhibits so that he's been diagnosed on the autism spectrum disorder, right? Okay, let's see. see here. All right, now I want to go into something else now. One sec, let me just go. Oh, great. Oh, great. I just have a thing. Urgent, an escaped psychiatric patient. They're currently searching for him. Christopher R. Morgan, an escaped psychiatric patient who fled from Garden Health Medical Center today at approximately 2:39 p.m. He was last seen wearing a long-sleeve white button-down shirt, black pants, and black shoes. Hold on, let me see if they found this guy. I don't know if they found him. Let me see. Let's take a little look-see. Wow, they said several. We have like really bad weather. 5 hours ago, they had slick conditions resulted in several jackknife tractor trailers. Oh, the kids jumped home tonight. Let me see. Let me just see if they found this guy. If you see Morgan, do not approach him. Okay. All right, I don't think, from what I'm reading, he doesn't seem to be dangerous, but okay. All right, let me go and get back to our other thing. I'm sorry that we took a little bit of a detour. All right, back to this. Now, Bryan Kohberger. Okay, here's something else. The DNA found under the victim's fingernails. People are talking about this. So, Bryan Kohberger's defense team. Hold on one second here. Has revealed a major development in his upcoming trial. A newly unsealed court filing shows that investigators found 3 unknown DNA profiles under victim Madison Mogen's fingernails. Clippings from Madison Mogen's left hand contained the samples, but testing has not determined their source. Comparisons between the profiles and Kohberger's DNA were inconclusive, meaning that he has neither been confirmed nor excluded as a contributor. Kohberger's defense is seeking to have the DNA evidence dismissed, arguing that the term inconclusive could mislead a jury into believing he might be one of the 3 individuals whose DNA was found under Mogen's nails. The attorneys also argue that the likelihood ratios, which simply compare the state's hypothesis, may be wrongly interpreted as a probability of identity. Kohberger claims that independent testing by the defense excluded him as a contributor. His defense team is also arguing that his autism diagnosis should bar him from receiving the death penalty. The attorneys claim that symptoms of autism could prejudice jurors against him, citing his limited facial expressions, atypical eye contact, as behaviors that might be misinterpreted as a lack of remorse or disrespect in the courtroom. His attorney, Ann Taylor, specifically points to media descriptions of Kohberger's expressions as eerie or creepy stare. Okay, so let's go quickly back to where we were. Let's see. Okay. Okay, so people are saying they're confused again by the 911 call, that they mentioned a person was unconscious and not breathing, but didn't mention blood, which must have been there in large quantities. They also did not mention another person in the room, Ethan. That's what we said, right? Let's see. So they think maybe the door was blocked by a body and that they were only able to see a small part of the body. Further, if the door was blocked by a body, how did the killer get out of the room? I don't know. Let's see here. So, lot. There's the transcript. I'm just trying to see if we have. Okay, this is something else. Hold on, we're going to look at the state's exhibits. Hold on a moment. Let's look at that. Defendants exhibits. Let's see this. Use of the term murder, inflammatory evidence, using the term psychopath or sociopath. So it says here, Bryan Kohberger, by and through his attorneys, hereby move the court for an order prohibiting the state from name calling. Specifically, this motion seeks to bar the use of the term psychopath or sociopath. Neither term is a proper diagnosis and is unequivocally unfairly prejudicial. Mr. Kohberger requests an order prohibiting the lawyers and witnesses from using the words psychopath and sociopath. And then there's something, witness identification by bushy eyebrows. Comes now Bryan C. Kohberger, by and through his attorneys. And it says, bar witness DM, that's Dylan, hereinafter Dylan, from using the words bushy eyebrows or identifying Mr. Kohberger in that manner. The issue of witness identification is a critical one in a trial that is the subject of much litigation. That is because the reliability of witness identification is the linchpin in determining the admissibility of identification information. Failure to challenge unreliable witness identification can result in finding that trial counsel's performance was deficient and provide a basis for overturning a conviction. When considering whether identification by a witness is reliable, the Idaho Supreme Court, blah, 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 it says, okay, let's get over here. Here we go. Bushy eyebrows. Here's the relevant facts. Here, I'll pull this over here so we can read this together. So you like to read together. Interviews on November 13th, 2022. Dylan was inside the house when the murders occurred and saw a figure dressed in black, hereinafter intruder, when she peeked out of her bedroom door around 4 a.m. Shortly after seeing the intruder, she went downstairs to Bethany's room. So she did go downstairs. The two girls fell asleep. Roughly 8 hours later, a 911 call was made from Bethany's phone at 11:56 a.m. More than 8 hours after seeing the intruder, Dylan was interviewed by law enforcement at the scene and at the police department. It was confusing to Dylan that the intruder looked at her but did not come towards her or say anything. When describing the intruder to Officer Nunes, where did I just go? How did I just lose my place? Hold on a second. Okay, at the scene, she described the height, build, and clothing of the intruder. Her description did not mention eyebrows. When she called Bethany before going downstairs to Bethany's room, Dylan said she was kind of in and out of it. I was really tired. So there's more stuff going on, text that we didn't see yet. Later, when she was interviewed at the police department, Detective Mowry inquired about facial features and asked Dylan if she knew what color the intruder's eyebrows were. And she said, everything was kind of blurry. I don't fully remember it. During the Mowry interview, Dylan again mentioned that she was in and out of it because she was so tired. Law enforcement took pictures of Dylan's room on November 13th and November 19th, and on the walls of her room, were many pictures of eyes with prominent eyebrows, many of which she had drawn. Some of the eyebrows are heavy, voluminous, puffy, or perhaps subjectively bushy. According to Detective Lake, he found artwork of human figures with an emphasis upon the eyes and eyebrows were pinned to corkboards. On November 17, 2022, 4 days later, Dylan was interviewed by Detective Gooch and indicated that she was really asleep and probably very drunk when she woke up around 4 a.m. on November 13th of 2022. Throughout the interview, Dylan expressed uncertainty about what she heard and saw and did not know if it was real or if it was a dream or if her mind was playing with her. She said it just doesn't make sense. She described the intruder and told Detective Gooch that she recalls seeing his eyebrows, his bushy eyebrows, but she did not recall the color of his eyebrows, She did not remember the eyes or the mouth, just the eyebrows. When she saw the intruder, she thought that the intruder was about 3 feet away from her, but that could be off since she was still a little bit drunk. She did not think that she could remember enough to give composite for a composite artist. She could just recall the bushy eyebrows, but not the shape or color of them. In this interview, Detective Gooch asked if Dylan had anxiety, which led to Dylan stating that she had a lot of lucid dreams of being kidnapped or chased. She indicated that she watched Criminal Minds and fell asleep to crime podcasts. These lucid dreams began in high school. Interviewed on December 1st of 2022, on December 1st, a half a month later, Dylan was interviewed again and described the intruder. She did not see his eyes, but she saw one eyebrow or two, but it was just like this bushy eyebrow. I could just see like an eyebrow, this bushy eyebrow. She did not remember the color or the shape of the eyebrow. She just remembered it being bushy. She did not remember if she saw one eyebrow or two. Throughout the interview, Dylan indicated that she had always had really bad dreams, lucid dreams, and scary dreams. She did not know what parts of her recollections were dreams and what parts were real. When she woke up that morning, she did not fully understand what was a dream or not. In this interview, she indicated that she thought that the person she saw was a fireman. On December 29th of 2022, a statement submitted by law enforcement in support of the arrest warrant used descriptive information from Dylan's interviews. Dylan described the figure as 5'10" or taller, male, not very muscular, but athletically built, with bushy eyebrows. An interview on December 30th, 2022, after the arrest of Mr. Kohberger. Hold on, I'm just trying to get my thing here. Okay. Mr. Kohberger, Dylan was interviewed by Detective Lake and Detective Tolson. When she learned that an arrest had been made, she found a mugshot of Mr. Kohberger online. When asked if Mr. Kohberger was the person that she saw in the house, she did not know if Mr. Kohberger was the intruder. She knew that the intruder had looked at her because of the bushy eyebrows. All that she remembered is some bushy eyebrow, and all black and some sort of mask. Subsequently, Dylan provided the grand jury testimony and was questioned about what the intruder was wearing. She was again uncertain, and that testimony is attached but not quoted verbatim here. Reliability of witness identification. Opportunity to view. Dylan peeked out her bed door 3 times after 4 a.m. on November 13, 2022. The third time she saw a figure dressed in black. At the scene, she described the intruder as, he was a little bit taller than me, and I couldn't really see much of him, but I'm almost positive he was wearing a full black outfit, and he had this mask that was just over his forehead and over his mouth, and he didn't say anything to me, like at all. At the police department, her description of the intruder was similar. And then I opened the door again, and the guy is right there. And he's maybe my height, a few inches taller, not like skinny, athletic build. He has all black. He's wearing this mask that covers just his forehead, and here, and it goes like around. He was white. There were no lights on the stairs. Dylan was uncertain whether either the kitchen light or the bathroom light was on. The kitchen light might have been on, but the twinkle lights in the living room may have been on. Degree of attention. Dylan acknowledged that her brain might have been fuzzy due to alcohol and sleepiness. When she saw the intruder, she stated that she had been drinking alcohol just hours prior to peeking out of her bedroom door sometime around 4 a.m. and seeing an intruder. She was intoxicated when she arrived home at 1:15 or 1:30ish. She was probably very drunk and tired when she saw the intruder at 4 a.m. Accuracy of the description. When asked if she could see the intruder's face, she testified that, "I wouldn't say I fully remember their face, but I remember seeing his eyebrows, so at some point I probably did see his face and don't remember it." During other interviews, she said he was wearing a mask. Level of certainty. During each interview, Dylan was uncertain. On December 30th, 2022, after the arrest of Mr. Kohberger, Dylan was interviewed by Detective Lake and Detective Tolson. When she learned that an arrest had been made, she found a mugshot of Mr. Kohberger online. When asked if Mr. Kohberger was the person that she saw in the house, she did not know if Mr. Kohberger was the intruder. She knew the man had looked at her because of the bushy eyebrows. All that she remembered is some bushy eyebrow, and all black, some sort of mask. Several weeks after the murders, Dylan thought the person she saw was a fireman. In her mind, Dylan thought that the intruder went out of the back sliding door, but she doesn't know if he actually went out the back door. The sliding back door was not visible from the doorway of Dylan's bedroom. Time between event and identification. At approximately 4 o'clock a.m. on November 13, 2022, Dylan saw the intruder. Roughly 8 hours later, the 911 call was made. More than 8 hours after seeing the intruder, Dylan provided a very limited and uncertain description of the intruder to 2 different officers. On November 17, 2022, 4 days later, Dylan did not think that she could sufficiently describe the intruder for a composite artist. On December 30th, 2022, after Mr. Kohberger's arrest, Dylan could not recognize Mr. Kohberger from a photo. Further, by the time that Dylan testifies at trial later this year, more than 3.5 years will have passed since the murders occurred on November 13th of 2022. Here's the argument. Hi 61. Case law in Idaho Criminal Rules 601 and 602 excludes evidence of bushy eyebrows. With certain exceptions, every person is competent to be a witness. IRE 601. Incompetency determined by the court occurs when persons whom the court finds are incapable of receiving just impressions of the facts about which they are examined or of relating them accurately. A witness must have sufficient personal knowledge of the matter to which he or she is testifying. Okay, let's go over here. Evidence to prove personal knowledge may consist of the witness's own testimony. When considering whether identification by a witness is reliable, the Idaho Supreme Court has applied the Manson-Biggers balancing test, which looks at the opportunity of the witness to view the criminal at the time of the crime, the witness's degree of attention, the accuracy of the witness's prior description of the criminal, the level of certainty demonstrated at the identification, and the length of time between the crime and the identification. When the Manson-Biggers balancing test is applied to the facts of this case, there is no reliable witness identification, as explained in detail above. Dylan's opportunity to view was seconds at most. Her attention was influenced by alcohol and sleepiness, and the only identifying attributes are height in relation to her own, a skinny athletic build, and a bushy eyebrow. he was wearing a mask. She has repeatedly, each time interviewed, expressed uncertainty about what she saw. These general descriptors could fit millions of individuals. Her uncertainty is repeated in each interview, and at least 8 hours passed before she interviewed for the first time. 6 weeks passed before she was interviewed by law enforcement the final time, and 6 months passed when she testified before the grand jury. Balancing the Manson-Biggers factors, there is no reliability of the physical characteristics that Dylan has reported. Mr. Kohberger does not have bushy eyebrows, but the artwork on Dylan's wall and that which should draw eyes with eyebrows could be described as bushy, full, or prominent. There is great risk that at trial in front of a jury, her testimony will be viewed as a clear identification of Mr. Kohberger. This would be a false identification and would prejudice the proceedings in a way that must be avoided. To be admissible, evidence must be relevant. Evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. Whether a fact is of consequence or material is determined by its relationship to the legal theories presented by the parties. In this case, evidence of bushy eyebrows is not relevant to the crimes charged and would not tend to make any material or disputed fact of these crimes charged in this case more probable or less probable than it would be without the evidence. The purpose of admitting such testimony is for identification. Hi there, Linda. Hi, Jeanette. Okay. For identification purposes, given the argument above, such testimony is inadmissible. There is no relevant reason to allow this testimony. This court may exclude evidence related to bushy eyebrows if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. The rule requires the court to balance the probative value of the evidence against the danger that the evidence may be unfairly prejudicial. Even assuming this court concludes that the descriptive words bushy eyebrows are somehow relevant, whatever minimal probative value they may have is substantially outweighed by the danger of unfair prejudice and confusion of these issues. Unfair prejudice is prejudice that tends to suggest a decision on an improper basis. Dylan could not recall enough details about the intruder to provide a description to a composite artist. Allowing her to use the descriptive words bushy eyebrows confuses the issues. If evidence of bushy eyebrows is presented to the jury might well believe that Mr. Kohberger is guilty simply because of bushy eyebrows. As a consequence, there is a danger that the jury would reach a decision of an improper basis due to evidence that is unfairly prejudicial. Conclusion. For the reasons addressed above, Mr. Kohberger respectfully requests the court grant his motion in limine to exclude Dylan from using the words bushy eyebrows to identify the intruder that she saw, and to exclude Dylan from identifying Mr. Kohberger based on bushy eyebrows. No bushy eyebrows. Okay, so bushy eyebrows, they want off the table there. Let's see what else we got. Okay. We did psychopath and sociopath. Use of the term murder. Sounds like something on TikTok, right? You can't say murder. Schmurder. So stupid. So stupid. Okay. Bryan Kohberger is coming now, buying through his attorneys on record with this motion. Whether the killings at issue are murder, as allegedly committed by Bryan Kohberger, or by an alternate suspect, or someone still unknown, is the ultimate issue. Each side will present this very argument to the jury. It is a matter of fact to be found by the jury after the court instructs the jury with the applicable instructions. To label Mr. Kohberger as a murderer, the alleged weapon consistent with an empty sheath as a murder weapon, or to assert that any of the 4 decedents was murdered by Mr. Kohberger denies his right to a fair trial and the right to be presumed innocent. Okay. IRE 403 allows exclusion of evidence that is unfairly prejudicial to a party. By analogy, the same principle should apply to terminology that is unfairly prejudicial. The use of the word murder during the course of a trial is unfairly prejudicial in that it asserts a factual and legal conclusion of the evidence, a determination which is left to the jury. The prosecutor, law enforcement, and medical examiner are viewed with authority and respect by most jurors. When persons with authority speak, lay people tend to believe their statements and conclusions. If the prosecution and/or its witnesses use the words in its case in chief, it would improperly imply to the jury that it is the prosecutor or witness's belief or opinion that the defendant is guilty of murder. This makes no sense. In every murder case, even in the opening statement, they tell you if it, this person sitting before you brutally murdered his, right? This is so crazy. Okay. Oh boy. If the prosecution and/or witnesses use these words in its case in chief, it would improperly imply to the jury that it is the prosecutor or witness's belief or opinion that the defendant is guilty of murder. This is improper opinion testimony, and under IRE 701 to 704, it is improper for the prosecution to express a personal belief unless the comment is based solely on inference. Expert testimony that concerns conclusions or opinions that the average juror is qualified to draw from the facts utilizing the juror's common sense and normal experience is inadmissible. Mr. Kohberger requests an order prohibiting the lawyers and witnesses from using the words murder, murderer, murdered, murder weapon, as well as derivative forms of the word murder. You got bushy eyebrows. Okay, let's look at this one. This is about unnoticed evidence. Here comes Bryan Kohberger. Idaho Rule of Evidence 404B states, evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with character. Permitted uses of other crimes, wrongs, or acts is when the evidence is being used for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. The prejudicial effect of a crime, wrong, or an act is that it induces the jury to believe the accused is more likely to have committed the crime on trial because he is a man of criminal character. Character evidence, therefore, takes the jury away from their primary consideration of the guilt or innocence of the particular crime on trial. The drafters of IRE 404B were careful to guard against the admission of evidence that would unduly prejudice the defendant while still allowing the prosecution to present probative evidence. For the reasons addressed above, Mr. Kohberger respectfully requests the court grant his motion in limine to exclude any reference to 404B, evidence that is unnoticed. Okay, this is Bryan Kohberger. He would like the exclusion of the Amazon click activity evidence at trial. So, says here that Mr. Kohberger, more specifically the defense, asserts that with the limited disclosures made by the state and the lack of raw data, lack of complete data, and the lack of disclosure of expert opinion, the lack of explanation of Amazon click activity, or any analysis related thereto, amounts to cherry-picked limited data that does not show a full picture compared to warrants that requested extensive data. The state's refining of all the Amazon history and Amazon click activity is out of context, incomplete, and unfairly prejudicial, thus making it inadmissible. Incomplete, irrelevant, and unfairly prejudicial evidence is barred by Rules 106, 401, 402, 403, 702, and 703 of the Idaho Rules of Evidence, and pursuant to the 6th, 8th, and 14th Amendments to the United States Constitution and Sections 13 of Article 1 of the Constitution of the State of Idaho. The motion should be read in conjunction with the motion in Line 2, excluding expert Shane Cox and any other expert the state intends to use regarding all Amazon evidence. The state disclosed Shane Cox as an expert who will testify about Mr. Kohberger's Amazon account, activity on the account to include logins, and Amazon click activity. The state wants to use very specific, narrow dates. The state has not defined Amazon click activity in any reports or expert disclosures, nor provided any opinions or analysis related to the limited data it has produced. The data produced is extremely narrow when compared to the more inclusive and broad warrants and subpoenas. Even in the face of the court telling the state its job was not done with its expert disclosures, nothing was produced in the state's rebuttal expert disclosures to further clarify the underlying data, analysis, and opinions it intends to offer regarding anything Amazon related. Mr. Kohberger faces his capital trial with no more than the state disclosing an expert testifying about dates related to Mr. Kohberger's Amazon account and the production of records and expertise regarding Amazon click activity, because Mr. Kohberger is placed in a position of guessing what the state's intentions are, and he has consulted an expert, David Howell, to attempt preparation. Mr. Kohberger has learned the limited disclosure leaves him unprepared to confront this evidence. In this ever-evolving age of technology, Amazon uses artificial intelligence to improve the customer experience by helping customers find products that match their interests and preferences. Amazon's AI-driven system does not just reflect searches. It actively shapes user behavior through recommendations, paid advertisements, and algorithmic reinforcement. Amazon's use of AI began well before 2022. Often when searching for something on Amazon, the end of the pathway does not tell the beginning of the pathway. This is because AI is continuously gathering information about the customer's interests and preferences and making suggestions along the way. You might like this. Customers, in the context of a household sharing an Amazon account, is all members of the family sharing the account. In other words, the purchases, searches, and machine learning impact all the users of the household Amazon account. Amazon's recommendation system, powered by AI and ML, significantly influences what users see and click on. In 2022, Amazon's AI-driven system did not passively reflect users' searches, but actively guided purchasing behavior based on predictive models. This means that a user's browsing and purchase history may not necessarily reflect deliberate intent, but could have been shaped by Amazon's algorithm. Omnichannel shopping exceeds beyond a single device. A user's Amazon activity spans across phones, tablets, laptops, desktops, and even smart home devices, all tracked and synchronized by Amazon. Shared household devices further complicate attribution as multiple users contribute to search history, ad targeting, and recommendation patterns. Excuse me. Devices, smartphones, computers, and tablets talk to one another and learn from each other. Hold on a minute. Hold on, I gotta get a drink. Gotta get a drink here. I gotta take just want to take a Muse next. Just okay. Take this. I have to get a glass of water because just stretch your legs for a second. I'll be right there. Stretch your legs for a second. I'll be right there. Gotta get some vitamins. I'll be right there. sorry about that. I had to just get something. So sorry. So sorry. Okay. I've got my other pack of vitamins here. Okay, so how are we doing on this? Do you want to keep going? Because we're going to keep going. If anybody bored and wants to leave, is anybody bored and wants to leave, or do you guys want to keep going? Is this interesting to you? Let me know. Okay, just let me know. Are you getting something out of this? Is this worth it? Anything? Hello there, everybody. You got a hot mic? I'm just getting my, what do we got? Hot mics. I'm just taking vitamins. We got no hot mics. Debbie Ju Scooter. Go, go, go. Lyle says, okay, keep going. All right. Okay, I just wanted to know, you know. Sometimes people might say, enough already. Enough already. I don't want to hear any more of this. Okay. You're getting more confused? Oh, no. I don't want to confuse you, Al. I just have to eat this like a little nut cluster so I don't get sick to my stomach because I just took about 16 vitamins. I know you joke. Hi. Okay. Let me just swallow this. Does his trial start soon? It starts in August. It starts in August. Hey, who gave a super chat? How come I didn't see it? I didn't hear the music. Who gave a super chat? Was that Mike? It probably was Mike. If it was Mike, am I right? Thank you, Mike, if you gave me the super chat. I just see it here in the chat revenue, but I didn't hear the thing. July 30th is like, but it doesn't really start till August, Scoots. So thank you, Mike. Thank you very much. Appreciate it very much. Thank you. Is Mike still here? Are you here, Mike? He probably was like, oh my gosh, she's so ungrateful. I'm out of here. I give her a super chat and she doesn't even know. Did you really delete it? I didn't know you could delete a super chat. Did you really delete it? I didn't know that was possible. Mike probably got pissed. Just a message? I didn't know, but I didn't know you could delete it. I don't know why it wasn't released, Elle. Mike was fine? Okay. Sorry, Mike. Thanks, Mike. I don't know where you went. Whisper to Me left too. I'm sorry if I'm crunching these things, but I don't want to puke, okay? And I've got a lot of reading to do. You gotta let me have a little tiny snack. I'm trying to be as quiet as possible. You know what I'm eating? I'm having blueberry vanilla. No, what am I having? I'll tell you what I'm having. I'm having nut and fruit clusters. Blueberry vanilla nut and fruit clusters. Does that sound good? No artificial anything. Oven baked goodness. Blueberries. Cashews. Pumpkin seeds, and almonds. They're super good. What's inside is blueberries, currants, almonds, cashews, pumpkin seeds, Himalayan pink salt, crisp rice, a little cane sugar, some brown rice syrup, and natural vanilla flavor. That's what I'm eating. And they are simply fit. Okay. And they're gluten-free. Sans gluten. Sans gluten. They're nice. I'm going to have 2 small clusters, and then we're going to go on. Hi, Jeanette. I won't crinkle the bag. I'm going to put the bag over here now. I'm done with the bag, Scooter, okay? I'm done with it. Scooter doesn't hear my mic anyway. Is my sound okay? I'm not crinkling. I'm chewing. That's my phone. That's my alarm, High 61. We have the wind. And it keeps picking up my wind chimes and it tells me someone's been detected in my backyard. Okay, I'm ready. Okay, sorry that I was chewing. I can't swallow them whole. Okay, where were we? Amazon's recommendation system. We're going to learn about Amazon right now. Powered by AI and ML, significantly influences what users see and click on. In 2022, Amazon's AI-driven system did not passively reflect users' searches, but actively guided purchasing behavior based on predictive models. Of course, right? If you're purchasing an air mattress, it's going to give you related things. It'll give you other air mattresses, bigger sizes, smaller sizes, right? Better quality. It'll give you air mattress sheets, all that stuff. We know that, how it works. This means that a user's browsing and purchase history may not necessarily reflect deliberate intent, but could have been shaped by Amazon's algorithm. Okay, what they're saying there is maybe you're shopping for an air mattress, but they recommend a tent, and you click on a tent, and maybe you have no intent to order a tent. See how I did that? But you've clicked on the tent just because they brought it up, and you didn't even know maybe that it was a tent. Now, let's say a crime is committed where you strangle someone with a tent, or it's alleged that you strangled someone to death with a tent, then they might use your Amazon search history and say, oh, so-and-so clicked over here on a tent. Okay. There we go. Now, omnichannel shopping extends beyond a single device. A user's Amazon activity spans across phones, tablets, laptops, desktops, and even smart home devices, all tracked and synchronized by Amazon. Shared household devices further complicate attribution as multiple users contribute to search history, ad targeting, and recommendation patterns. Devices, smartphones, computers, and tablets talk to one another and learn from one another. For example, ads that pop up on Facebook and YouTube can be influenced by what you searched for elsewhere. Yeah, or what you said. Many times I'll say something and I'll see a video in my YouTube feed. It works on Facebook too. Okay. Amazon's advertising system plays a critical role in shaping what users see and click on. Unlike a simple search and buy process, Amazon's AI-driven ad placements, keyword targeting, and personalized recommendations actively guide users towards specific products. Amazon specializes in driving suggestions that are not actively searched for by a purchaser. In this case, the state's refining or limiting the Amazon click activity to a specific click or a specific item excludes data, takes things out of context, and could tell a completely inaccurate story to cause the jury to speculate about the intent. Full Amazon advertising logs and recommendation data must be reviewed to determine whether a purchase was truly user-initiated or heavily influenced by Amazon's AI. The data produced does not identify the purchaser through means other than by name or credit card, nor does it identify the device from which the item was purchased. For example, suppose someone buys a pair of binoculars on Amazon on a household account with 4 users. Doesn't this sound like a math word problem? Yes, I'm going to ask you to create a formula to solve it. Okay, that's what it sounds like. For example, suppose someone buys a pair of binoculars on Amazon on a household account with 4 users. If each user spends exactly 2 hours on the family computer, who in the household either searched for binoculars or through some other searches triggered Amazon's AI to do a target ad for binoculars? How long were they searching for the binoculars? Were they wish listed for a period of time? Were they placed in the cart and removed? All which could indicate indecisiveness? How about if Dad wanted a pair of binoculars for Christmas, and this was right around Christmas time, right? And he had told his family, theoretically, 3 of those users could have searched for binoculars, right? Okay. Did an Amazon AI-generated ad cause the purchase of binoculars as a result of a search for some other product? Were other ads shown to the purchaser by Amazon? How long were the binoculars searched before being actually purchased? What types were considered or placed as target ads by Amazon? What other purchases made around the same time that provide context? Other purchases made around the same time can provide context to the intent of the purchaser. In our example, the shopper also purchased a sleeping bag, a tent, a cook stove, long johns, and a safety vest for an upcoming hunting trip. Compare the possibility that a purchaser instead bought rope, night vision goggles, zip ties, duct tape, a tarp, and a stun gun. Ooh. These combined purchases could show a completely different intent. Amazon sponsored products and display ads allow sellers to pay for visibility, meaning that if someone searched for binoculars, camping gear, or outdoor equipment, they could have been ad targeted with a gun or bear spray listing, not because they were looking for these items, but because an advertiser paid for it to appear. I just heard a beep. Did you see that? Sellers using Amazon's as a platform to sell specifically chose terms to prompt ads, and those terms may be completely unrelated to the item they are selling, yet that term will target an ad to get a purchaser's attention. Similarly, the frequently bought together, and customers also bought, sections, often assumed to reflect organic trends, are manipulated by paid placements. You heard that sound? I don't know what that was. Shared Amazon accounts also impact click activity or search history. This is another example of incomplete or limited data leading to an improper conclusion in a shared household Amazon account. One person in a household interest in certain items impacts the entire household. This can even happen by the mere existence of proximity to a Wi-Fi network shared by others. Okay, now they're going to go on to that. Now they're going to go on to see proximity advertising and perceived eavesdropping. From the Times. Okay, that's not the New York Times. That's, okay. This article explains the phenomenon where where the individuals believe their phones are eavesdropping on conversations, explaining that targeted ads often result from proximity advertising. The Amazon click activity, in this case, is for an account which is a household account shared by Mr. Kohberger and other family members. The click history includes items searched for or viewed on Amazon which might be related to a search conducted by other family members, or might be items suggested by Amazon based on prior interest or prior purchases, and AI and ML making recommendations that look like click activity. Mr. Kohberger believes that the state intends to use Amazon evidence to prove elements of its case. To allow such in the face of explanation above and the failure to disclose would be unconstitutional and in violation of the rules of evidence. Rule 106 guards against introduction of incomplete evidence. In fairness, incomplete Amazon data and click activity should not be offered as evidence. Cherry-picking specific clicks or purchases out of an Amazon click history removes all of the context explained above. Idaho Rule of Evidence 106 identifies the confines of the completeness doctrine. If a party introduces all or part of a writing or recorded statement, an adverse party may require the introduction at that time of any other part or any other writing or recorded statement that in fairness ought to be considered at the same time. Under the common law rule that underpins Idaho's Rule of Evidence 106, the reason for the completion doctrine is that there's a danger that an out-of-context statement may create such prejudice that it's impossible to repair by a subsequent presentation of additional material. See, it simply wouldn't be feasible. Thus, Rule 106 requires the admission of those portions of the statement that are necessary to qualify, explain, or place into context the portion already introduced. What? Okay. Evidence must be relevant to be admissible. The test for relevancy is set out in Evidence is relevant if it has a tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. Okay, so it's going to talk. Okay, let's go. Conclusion. For these reasons addressed above, Mr. Kohberger respectfully requests this court grant his motion in limine to exclude any Amazon and Amazon click activity evidence because it is improperly isolated, out of context, does not take into account advertising influence and omni-channel factors. Mr. Kohberger intends to offer expert testimony of David Howell at the motion hearing on April 9th, 2025. Okay. He doesn't want that Amazon stuff in there. Yeah, those are my alarms. Someone's been detected in my backyard. Someone's lingering in my backyard. It's really windy. And if I put the cameras on where it isolates the event, you'd hear how windy it is and how the wind chimes are. There it goes again. Someone is lingering in your backyard. Okay. Let's go on. Let's go on. So we talked about murder. We talked about psychopath and sociopath. We talked about bushy eyebrows. Let's talk about him. Let's see if this one, what we got here. Let's talk about this one. Comes now, the state of Idaho. Okay, this is the prosecution. Let's see what they say. The state is requesting an order pursuant to Idaho Constitution and Idaho Code allowing immediate family members of the homicide victims to be present during the entire trial, regardless of when they are scheduled to testify. So what they're saying now is the family members want to be there. A lot of times, some courts limit the witnesses from being in the courtroom before they testify. So now they're saying that they want to allow immediate family members of the homicide victims to be present during the entire trial, regardless of when they are scheduled to testify. A crime victim, as defined by statute, has the following rights: to be present at all criminal justice proceedings. Each victim of a criminal or juvenile offense shall be permitted to be present at all criminal justice proceedings. The statute extends this right equally to the immediate family members of the homicide victims. The legislature did not define immediate families in this section. Nonetheless, the legislature has defined it elsewhere. For instance, immediate family member means a parent, mother-in-law, father-in-law, husband, wife, sister, brother, brother-in-law, sister-in-law, son-in-law, daughter-in-law, son or daughter. Likewise, an immediate family member means the spouse, children, brother, sister, mother, or father. Black's Law Dictionary defines immediate family member as a person's parent, spouse, children, and siblings. A person's parent, spouse, children, and siblings, as well as those of the parent's spouse. Person's spouse. The state has attached a list of the immediate family members the state believes should be considered victims by statute and therefore should be allowed to be present, if they choose, during the entire trial, regardless of whether or when they testify. The state respectfully moves for an order in limine specifying immediate family members under that statute and allowing these immediate family members to remain in the courtroom during the entirety of the trial. Okay. Now, And let me move this because this is an exhibit. It goes with this. Okay, so here's what it is identifying: the brother of Ethan Chapin, the father of Ethan Chapin, the sister of Ethan Chapin, and the mother of Ethan Chapin. The sister of Kaylee Gonsalves, the mother of Kaylee Gonsalves, the father of Kaylee Gonsalves, the brother of Kaylee Gonsalves, the grandmother of Kaylee Gonsalves, and the grandmother of Kaylee Gonsalves. Excuse me. Xana. The mother of Xana Kernodle, the sister of Xana Kernodle, the father of Xana Kernodle, Madison Mogan, the grandmother of Madison Mogan, the stepmother of Madison Mogan, the stepsister of Madison Mogan, the mother of Madison Mogan, the stepfather of Madison Mogan, and the father of Madison Mogan. Okay. Let's see what we have now. What's this? Let's see what this is about. See what this is about. Bryan Kohberger, by and through his attorneys of record. This is a motion in limine number 1 regarding inflammatory evidence. Mr. Kohberger respectfully requests this court order the state to not try the case through eliciting testimony and other evidence that is exceptionally inflammatory. Presenting the case in an emotional and inflammatory way is unfairly prejudicial. Any probative value is less than the danger. Additionally, the prosecution should not present the same information in a variety of ways which is misleading or cumulative and a waste of time. Although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. This case contains over 68 terabytes of data. The data contains thousands of photographs. Many depict roughly the same content. There are photographs that depict the deceased as well as the same location without the deceased. Multiple officers took photographs of the same areas. Additionally, there are many hours of body-worn camera footage. Body-worn footage depicts the officers moving throughout the house. There are hundreds of photographs of autopsy proceedings. In addition to this evidence, over 100 officers and investigators have been involved in the case, and hundreds of people have been interviewed. Mr. Kohberger seeks to protect the integrity of his trial and requests an order preventing inflammatory evidence, including testimonial evidence, be excluded. Appeals to emotion, passion, or prejudice of the jury through use of inflammatory tactics are impermissible. Mr. Kohberger acknowledges the Idaho Supreme Court has held that a photograph cannot be excluded merely on the basis of being gruesome. However, Mr. Kohberger is not making that motion. Rather, he is requesting the state be prevented from introducing inflammatory evidence. Okay, multiple studies have found that mock jurors are more likely to convict when exposed to graphic photos. Other studies have shown that judicial instructions to ignore such evidence are ineffective. while some have actually found such instructions cause jurors to place more emphasis on that evidence. Mr. Kohberger's right to a fair trial, free from irrelevant, cumulative, and unfairly prejudicial evidence, is guaranteed by the Constitution of the State of Idaho and the United States of America, would be violated to allow exhibits depicting gruesome details or the emotional reactions of the police officers at the scene or during their testimony during trial. This sounds crazy that they're trying to limit all this. You know, it sounds really nuts, doesn't it? Okay, let's see. So we went through the term of murder, psychopath, inconclusive data. And this is for the DNA. Okay, Bryan Kohberger says, motion in limine number 6, Rylene Nolan, and reference to touch and contact DNA. Comes now. Bryan Kohberger, by and through his attorneys of record and pursuant to Idaho rules of evidence, moves the Honorable Court for an order in limine excluding the testimony of Rylene Nolan, and any testimony referencing the terms touch or contact DNA, purporting to be an opinion of the means and mechanism for DNA being placed on the sheath by any witness called to testify about DNA, both the term touch or contact DNA or any opinion regarding how DNA ends up on an item is misleading, in that it assumes facts that must be proven. It would be confusing to the jury and a waste substantial time in debunking the testimony of an expert that is outside the purview of the field of expertise and qualifications. Furthermore, the opinions of this expert has not been disclosed to Mr. Kohberger as set forth below. The how and when of DNA arrives on an object cannot be specifically determined and is not the proper subject of expert testimony. The use of this language confuses and misleads the finder of fact and is barred by the rules 402, 403, as well as due process, in that the evidence is overly prejudicial. The erroneous admission of irrelevant and prejudicial evidence will offend due process when it renders a trial fundamentally unfair. Here's the relevant facts, folks. A knife sheath that was recovered, tucked under the covers next to Ms. Mogan at 1122 King Road, Moscow, Idaho, on November 13th of 2022. And that sheath was tested using standard DNA STR methods by the Idaho State Police. A swab from the sheath resulted in a single source male profile. The profile was uploaded to the CODIS DNA database and resulted in no hits to known offenders. In its disclosures, the government had indicated that Rylene Nolan from the ISP lab will testify as follows. Ms. Nolan will also testify to touch DNA and transfer DNA. Specifically, Nolan will testify to the characteristics and nature of touch DNA, including how it is deposited, transferred to an item of evidence, the methods used to collect and preserve touch DNA samples from items of evidence, the procedures and the protocols used by forensic scientists to extract and analyze touch DNA, the manner in which results from touch DNA samples are interpreted, and the reliability of touch DNA analysis and its acceptability in the field of forensic science. Nolan will also testify to the potential for DNA to transfer between an individual and an object, including the distinction between primary and secondary transfer and the factors influencing the likelihood of transfer. On February 17, 2025, the state produced a second round of disclosures, including one from Riley Nolan. As with the first disclosure, the focus of the second disclosure is touch contact DNA and direct versus indirect transfer, although conceding that currently DNA technology cannot conclusively answer the question, the state offers the following opinion. Many complicated factors can influence the likelihood of transferred DNA and the persistence of the transferred DNA after deposition. Current DNA technology cannot conclusively answer the question of when DNA was deposited on an item or by what mechanism, i.e., direct or indirect transfer. It is possible the DNA detected resulted from secondary transfer. However, based on Nolan's training and expertise, it is her opinion, given the quantity of DNA detected and given the DNA profile obtained as single source, it is more likely the result of a direct transfer. And the argument is introduction to the concept of touch DNA and transfer opinions. The terms touch and contact DNA came into use as the forensic community shifted from the testing of obvious identifiable stains such as blood or semen to samples that cannot be identified via biological tests based on the increasingly sensitivity of DNA tests. Samples such as swabs from steering wheels of a carjacked vehicle or window jambs in a burglary were collected and tested on the theory that a person would have in contact with the object and left DNA behind in the form of skin or other cells, hence the terms touch or contact. The forensic community began to conduct research into the question of how DNA in the form of biological material moves in the environment, and this research led to the conclusion that it is impossible to determine how a particular deposit of DNA came to be on an object. In 2013, an article which reviewed the state of the research at the time made the following conclusions. Full DNA profiles can be recovered from items that have not been touched, but have been in the vicinity of someone speaking or coughing. It is not possible to establish from the amount of DNA recovered from a surface whether the DNA was deposited there by a single touch or by regular use. It is not possible to use the amount of DNA recovered from an item of interest to inform whether the DNA was deposited by direct contact or indirect transfer. It is impossible to know from the quality of a DNA profile obtained whether the DNA was deposited by direct contact or indirect transfer. Examples of indirect transfer of what might be characterized as touch or contact DNA are numerous and are summarized in the 2 review articles described above. We're not going to go into all that because you guys know that. Using a less descriptive term such as trace DNA is a more appropriate term to be used in casework when the source and mode of deposition are unknown. Despite this wealth of information and scientific study, the authors conclude that more work is necessary and the expertise to offer activity-level opinions. The how and when is beyond the expertise of crime lab analysts. Then, in 2024, the National Institute of Standards published a document entitled Forensic DNA Interpretation and Human Factors, Improving Practice Through a Systems Approach. This document was the result of extensive work and years of public review and comment. The expert working group EWG on human factors in forensic DNA interpretation began work in 2020 with the goal of recommending strategies for improving the production, evaluation, and communication of DNA results. The EWG consisted of experts in the field of forensic DNA and was subject to repeated rounds of public comment from the greater forensic community. Most notably, for this court, the EWG addressed the question of transfer and the ability of experts to proffer opinions. The EWG addressed the following question. But a further important question is what activities led to the presence of that DNA. With the increased sensitivity of DNA techniques and sophisticated software, a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swabbed. Alternatively, a person's DNA may be present when they were not involved in the crime. Therefore, considering how or when the DNA may have been deposited or why it was not recovered can be vital. Except in ground truth known experiments, where an individual is observed to have been in contact with a surface location, it is not possible to know whether the transfer was direct or indirect. The assessment of what is called TPPR, transfer, persistence, prevalence, and recovery, is a separate skill, distinct from standard DNA profiling and interpretation. There are not adequate educational opportunities to inform these types of issues. Within the United States, the EWG concluded that an expert rarely, if ever, has all the information needed to perform a robust, balanced, and transparent evaluation of biological results regarding transfer or specific activities on the witness stand. Okay, the only conclusion that this court can draw is that the opinions regarding the means and manner in which DNA was deposited on an item is not considered a proper topic of expert opinion for a DNA analyst, and likely to lead to undue prejudice to Mr. Kohberger and would render his trial fundamentally unfair. It's fundamentally unfair. Okay. This court must exclude the opinion of Riley Noland. As set forth above, an expert cannot offer opinions within their expertise. The expertise of the typical lab analyst is not sufficient to allow them to be considered an expert in the area. The mechanism of DNA transfer, Noland's disclosure concedes as much in that she acknowledges that current methods cannot conclusively offer an answer to the question of how and when and how. Noland cannot be allowed to substitute her judgment in the face of the weight of the forensic community's agreement that the science and literature does not support any analyst testifying, and about the when and how of transfer. The opinion falls outside the norm for forensic DNA experts and would be highly speculative. Given the nature of the opinion proffered and the recommendations in NIST Human Factors Report, the opinion would be highly speculative. In addition, it would have the tendency to mislead and confuse the jury and would require undue consumption of time to refute with the scientific articles and reports that clearly conflict with this proffered testimony. This is disclosure. Is not proper rebuttal testimony. Noland's disclosure contains an opinion that is not rebuttal, but appears to be the state's theory of the case that the DNA from Mr. Kohberger arrived on the knife sheath via direct contact. A close reading of the disclosure from Mr. Kohberger's DNA witness, Dr. Ruth Ballard, does not contain any opinion regarding the how and when the DNA arrived on the sheath. The testimony should be excluded. The court must exclude the use of the terms touch or contact DNA. This court, let's see, what do we have here? Hence, the terms touch and contact are misleading in that the forensic community has determined through empirical research that it is not possible for a DNA expert to testify as to how DNA was deposited on an item. The two terms insinuate that the deposit must have come from direct contact with an object rather than the myriad of other possible means of transfer documented in the literature. Furthermore, allowing testimony regarding the manner in which the DNA was deposited on the sheath would implicate the same concerns that the use of the two terms touch and contact evoke. The forensic community consensus and an extensive body of research shows that the how and when opinions in DNA testing far exceed the expertise of a DNA analyst and are not founded in science. In this case, DNA evidence that implicates Mr. Kohberger is the DNA found on the sheath found in the residence. From the lab reports and notes, as well as the recent testimony by Riley Nowland, it appears that at the sample Q1, it was a swabbing of the leather strap on the sheath as well as the interior of the snap, not the outer snap surface, which apparently was not sampled in order to preserve the surface for fingerprinting. No serological testing was done on the area swabbed for Q1 to identify any biological material. An area identified as Q1.4 swabs of the stains on back of the sheath tested presumptively positive for blood and was DNA tested. Mr. Kohberger was excluded from this particular sample, which was identified as a mixture. Thus, the government has the burden to prove the when and how of the DNA identified in Q1.1. Allowing the use of these two terms would mislead the jury to believe that there is evidence to support the conclusion of direct contact when, in fact, there is no direct evidence. The admission of these terms would lead to a substantial waste of time in that it would require not only extensive cross-examination of the government's witness on the topic, but also rebuttal testimony from the defense experts on this question. Furthermore, the use of the language would unfairly prejudice Mr. Kohberger. Unfair prejudice is prejudice that tends to suggest a decision on an improper basis. If the language is used, the jury might well believe through expert testimony as opposed to factual testimony that Mr. Kohberger left his DNA on the sheath via direct contact, a fact that the government must prove. As a consequence, there is a danger that the jury would reach a decision on an improper basis due to evidence that is unfairly prejudicial. Okay, so in conclusion, the question of how and when is not for a lab analyst, and as the EWG points out, there is no training program in the United States that would provide expertise for such an opinion. Mr. Kohberger respectfully requests this court grant his motion in limine to exclude any use of the language touch and contact in the context of the DNA testing of the sheath and any opinion of how and when the DNA on the sheath was deposited. Okay, let's see what else we have. Bushy. Okay, let's see. What is this? What is this? What is this? Okay, this is the state of Idaho, and they say that they respectfully move the court for an order in limine prohibiting the defense from making any reference to the state attempting to kill their client, Bryan C. Kohberger. The state brings this motion based on defense counsel's repeated references to the state attempting to kill their client. On October 26 of 2023, defendant in his reply to the state's objection to the defendant's second motion to dismiss the indictment, page 18, he states the state has decided to attempt to kill Mr. Kohberger. On October 26 of 2023, during oral argument on the defendant's motion to dismiss the indictment, defense counsel stated This does not rise to what we would expect our government to do in this scenario where they are trying to kill one of us. Again, on January 25th of 2024, during oral arguments on the defendant's motion to reconsider, defense counsel stated, particularly in a case where the state's decided that it wants to try to kill someone, pursuant to 18-4004A, the state has filed a notice of intent to seek the death penalty. Upon the finding of guilt, the state intends to provide statutory aggravating factors which could enable a jury to impose the death penalty. This is the process laid out by Idaho law. Any other characterization, such as the statements that the state is attempting to kill, only serves to inflame the passions of the jury. The statements are irrelevant, i.e., does not make a fact more or less probable, has no consequence in determining the action to the issues before the jury, the guilt or innocence of the defendant on the charged offenses. In addition, such statements carry the substantial danger of confusing the issues and misleading the jury, thus failing the IRE balancing test, even if deemed relevant. This is further supported by the Idaho criminal jury instructions, which instructs the jury, at the conclusion of the trial, you will decide whether the state has proved the defendant guilty beyond a reasonable doubt. Do not concern yourself with the subject of penalty or punishment. The subject must not in any way affect your verdict. For the above reasons, the state requests the court prohibit defense counsel from making any references to the state attempting to kill. Okay. Let's see. Let's see. Okay, let's see what this is. Bryan Kohberger moves the court for an order preventing the state from using Mr. Kohberger's mental health diagnosis of autism and the characteristics of his autism as evidence in its case. The motion is meant to protect Mr. Kohberger's 5th, 6th, and 14th Amendment rights under the United States Constitution and Article 1, Section 6 and 13 of the Idaho Constitution. Mr. Kohberger has a diagnosis of autism, and he displays characteristics consistent with autism. A comprehensive neuropsychological evaluation of Mr. Kohberger conducted by Dr. Rachel Orr, PsyD, ABPPCN, found that Mr. Kohberger continues to exhibit all the core diagnostic features of ASD, currently with significant impact on his daily life. Mr. Kohberger shares characteristics such as social challenges, preservation and lack of reciprocity. The characteristics are noted, but by those unfamiliar with autism, as not picking up on social cues. In evaluating Mr. Kohberger, Dr. Orr found that he has displayed lifelong deficits in social, emotional reciprocity, including limited perspective taking, and limited, I should put my glasses on, sharing of affect emotions of others. Example A, at 16. Because of his autism, others may see Bryan as not recognizing social cues, continuing to talk to others when the conversation would naturally end. Over-focusing on a topic or a hobby of interest, or talking about the same topic repeatedly, using a complicated vocabulary, or seeming self-absorbed. Bryan's autism is also accompanied by obsessive compulsiveness and an eating disorder. Since childhood, Mr. Kohberger has exhibited compulsions around getting things in his eyes, hand washing, and other germ-avoidant behaviors. Well, I don't know how a germaphobe, okay, number one, a germaphobe would murder 4 people in a bloody way that would, that doesn't go with germaphobe, okay, it does not at all. Or getting things in his eyes, or his hands being dirty. Yeah, okay. These characteristics must not be used by the prosecution as factors for the jury to consider as aggravators. Evidence of mental illness in capital case litigation is mitigation evidence. The United States Supreme Court and Idaho Supreme Court recognize evidence of a defendant's mental illness as mitigating. Mr. Kohberger's autism is mitigation evidence. It is inappropriate for the prosecution to wrap mitigating evidence as into an aggravator. Allowing the state to argue that Mr. Kohberger's mental illness is an aggravating factor that violates the 8th and 14th Amendments by precluding the jury from giving meaningful consideration and effect to that mitigating evidence. Mr. Kohberger points the court, individual sentencing in capital cases reflects the concern of the court for fairness in proceedings. The court has defined mitigating factors to be any evidence that might serve as a basis for a sentence less than death. Allowing the state to argue that Mr. Kohberger's mental health issues are actually aggravators unlawfully interferes with the jury's ability to give effect to the mitigation evidence. It is more prejudicial than if the sentencer was told to ignore it or give it no weight, which is prohibited by law. The state also cannot argue that factors which are casually related to Mr. Kohberger's mental health issues should serve to aggravate the punishment, i.e. that they contribute to future dangerousness, propensity to kill, or contribute to aggravators regarding heinousness of the crime. That is functionally the same thing as arguing that he should be sentenced to death because of his mental illness, which is constitutionally impermissible. Allowing the state to argue that Mr. Kohberger's mental health and developmental disability are aggravators violates the 8th and 14th Amendments by criminalizing his status as a disabled person. Criminalization of a person's mere status violates the 8th Amendment as applied to the states through the 14th Amendment. It is unlikely Let's see. Justice. The same reasoning applies here. Mr. Kohberger cannot be sentenced to death due to his mere status as a person with ASD, a disability which, in fact, renders him less culpable and which should be considered by the jury only as mitigation. Mr. Kohberger respectfully requests the court prevent the state from using his diagnosis of autism or any characteristics therefore as an aggravator if a sentencing proceeding is held. Did we go over this one? Motion to strike the death penalty. Bryan Kohberger. Mr. Kohberger relies on his motion to strike the death penalty. Autism spectrum disorder, right to be free from cruel and unusual punishment, has the right to due process, has a right to a fair trial, has a right to counsel, his right to present a defense, his right to a reliable sentencing determination, and other rights safeguarded by the 5th, 6th, 8th, 14th Amendments to the United States Constitution, and Article 1, Sections 1, 2, 6, 7, and 13 of Idaho State Constitution. Mr. Kohberger is aware of the deadline previously imposed by the court's scheduling order, but has good cause for filing this motion at this time. Good cause is laid out in an affidavit attached but filed under seal. A notarized signed copy will be provided once received from Dr. Reynolds. People with ASD, autism spectrum disorder, including Mr. Kohberger, exhibit deficits in nearly all the same areas cited by the court in concluding that it is unconstitutional for people with intellectual disabilities to be sentenced to death because such sentences are not proportional and cannot be reliably imposed. Indeed, the pervasive media coverage emphasizing symptoms of Mr. Kohberger's disability demonstrates the very risks recognized by the court and are already being realized to his prejudice. Accordingly, the court must strike death as a sentencing option in this case. People with ASD exhibit impairments in nearly all of these areas. There are two primary diagnostic criteria for ASD. First, a person must display persistent deficits in social communication and interaction across multiple contexts as manifested by deficits in all three of the following areas: social, emotional reciprocity, nonverbal communication behaviors used for social interaction, and 3, developing, maintaining, and understanding relationships. A comprehensive neuropsychological evaluation of Mr. Kohberger, conducted by Dr. Rachel Orr, found that Mr. Kohberger continues to exhibit all the core diagnostic features of ASD currently, with significant impact on his daily life. Social deficits, including a diminished ability to understand the reactions of others, is perhaps the most widely recognized characteristics of ASD. People with ASD often have difficulty identifying the emotional or mental states of others and how to respond appropriately. Where did I? Okay. let's go here now. Let's see where I was. Accordingly, if it is difficult for people with ASD to interpret and respond to social cues, particularly when those cues are nonverbal, along with difficulty recognizing the emotions of others, people with ASD often struggle to recognize and regulate their own emotions. This can manifest as diminished capacity to control impulses. Dr. Orr observed Mr. Kohberger's impulsive tendencies throughout her evaluation, which were also reported by his family. Additionally, a need to engage in repetitive behaviors or interests is one of the diagnostic domains of ASD, CDC Supra. For many people with ASD, this manifests in compulsive behavior that cannot easily be controlled by rational thinking. Since childhood, Mr. Kohberger has exhibited compulsions around hand washing and other cleaning behaviors. Mr. Kohberger has strong verbal abilities. He failed to recognize multiple idioms during Dr. Orr's evaluation. Dr. Orr noted that his language was often over-inclusive, disorganized, highly repetitive, and overly formal. Like people with intellectual disabilities, people with autism also have diminished capacities to understand and process information and to abstract from mistakes and learn from experience. Particular people with ASD are generally able to identify concepts and learn established rules, but struggle with concept formation or the ability to develop new concepts based upon experience. In other words, people with ASD may be able to comprehend information, but like people with intellectual disabilities, they have difficulty extrapolating that information and applying it to a new domain. These deficits in conceptual reasoning and problem solving are apparent even among people with ASD who have average or above average general intelligence. Indeed, despite his high baseline intelligence, Mr. Kohberger exhibits slow verbal processing and weakness in certain areas of executive functioning, including cognitive flexibility and organizational approach. Dr. Orr observed that Mr. Kohberger tended to perceive information in a more piecemeal manner and was highly distractible. As a result of these impairments, people with ASD show diminished adaptive functioning, much like people with intellectual disabilities. Adaptive functioning encompasses those skills essential for real-world, everyday functioning that generally fall within the broad areas of daily living skills, socialization, and communication. Notably, people with ASD exhibit adaptive functioning that falls far below what would be expected given their cognitive ability. Follows that people with ASD who are similarly impaired in this area should not be sentenced to death. In order, the deterrent and retributive aims of the death penalty are not met by executing people with ASD. In order for a death sentence to meet the Eighth Amendment's proportionality requirement, it must satisfy two penological goals of capital punishment. The Adkins Court concluded that neither aim was met by executing intellectually disabled defendants. Discussing retribution. Yikes. I'll blow your house in, the court reasoned. Okay, let's see here what we got. characteristics of ASD make deterrence even less salient as an aim of punishment. The repetitive behaviors and the fixations that are key diagnostic criteria of ASD mean that for many defendants with ASD, their offending behavior is compulsive, cannot be curbed by a rational cost-benefit analysis. Additionally, because people with ASD have difficulty with abstract thinking and extrapolating from one scenario to another, they may not easily connect their present actions to a potential future outcome. Executing people with ASD does not meaningfully satisfy the penological aims of retribution or deterrence. Accordingly, sentencing people with ASD to death violates the Eighth Amendment. The Eighth Amendment prohibits excessive punishments. Whether a punishment is excessive must be judged by current prevailing standards of decency. The past 4 decades have seen a significant evolution in the understanding of ASD. Although infantile autism was first described by psychiatrist Leo Kanner in 1943, it was not included in the Diagnostic and Statistical Manual, the DSM, as one of several pervasive developmental disorders until 1980. When the DSM was revised, 7 years later, published as DSM-3R, the condition was renamed from infantile autism to autism disorder to encompass all ages and developmental levels. The 4th edition of the DSM, published in 1994, recognized Asperger's syndrome and autistic disorder as separate diagnoses with the broad category of pervasive developmental disorders. The current version of the DSM, published in 2013 as DSM-5, reflects a major shift in the understanding of autism. The DSM-5 established a comprehensive diagnosis of autism spectrum disorder, which replaces Asperger's syndrome and autistic disorder. The current ASD diagnosis recognizes autism as a spectrum of conditions. As the psychological community's understanding of ASD has evolved, so has awareness of the condition. ASD is now the fastest growing developmental disability in the United States. The increase in awareness of ASD has coincided with greater efforts by the criminal legal system to account for the role that intellectual disabilities, developmental disorders, and mental health conditions play in offending behavior. For example, as of December 31st, 2023, there were 655 mental health courts in the United States across 42 states and the District of Columbia. ASD specifically has been deemed relevant to defendants' interactions with law enforcement and ability to formulate criminal intent. The defendant proffered the evidence to assist the jury in okay, that's the case. Hold on a minute. The intersection between ASD and the death penalty has gained recent attention with the case of Robert Robertson, an autistic man sentenced to death in Texas for the alleged murder of his daughter. In addition to challenging the scientific flaws underpinning his daughter's diagnosis of shaken baby syndrome, Mr. Robertson argues that his ASD contributed to his wrongful conviction because law enforcement misinterpreted his flat affect during the tragedy as evidence of guilt. See the petition for commutation of death sentence to a lesser penalty. Okay, let's see here. Now, Mr. Robertson's plight, including his argument about ASD, has attracted widespread media attention. Okay, let's see here. And they're giving another one. Mr. Robertson has also garnered support from a broad coalition ranging from the lead detective who investigated his case to judges, psychologists, and advocates. It has now been over 2 decades since the United States Supreme Court held that evolving standards of decency mandate a categorical bar on the execution of people with intellectual disabilities. As detailed in Part 1, Supra, people with ASD exhibit many of the very same impairments as people with intellectual disabilities. The overlap in is apparent in Idaho's own intellectual disability statute, which, in addition to showing a significantly sub-average intellectual functioning, requires a showing of a significant limitation in adaptive functioning in at least two of the following skill areas: communication, self-care, home living, social or interpersonal skills, use of community resources, self-direction, functional academic skills, work, leisure, health, and safety. If evolving standards of decency 20 years ago condemned the execution of people with intellectual disabilities due to the impairments associated with their condition, it follows that the execution of people with ASD who share nearly identical deficits is equally deplorable. Death sentences for people with ASD are inherently unreliable because defendants with ASD cannot present mitigation evidence that will be meaningfully considered by the jury. Defendants with ASD are less able to meaningfully assist their counsel. Okay, so let's see here. The demeanor of a defendant with ASD will likely create an unwarranted impression of a lack of remorse. Mr. Kohberger, let's see this here. Mr. Kohberger aims to be as helpful as possible in preparing the case. These mental deficiencies will invade every detail of that aid, from client relationship to fact investigation to mitigation investigation to pre-trial motions to trial strategy. No matter how helpful Mr. Kohberger may wish to be, it is simply not possible for him to aid counsel in a way that someone without the deficits accompanying ASD would be able to. This lack of ability is the precise concern articulated in Atkins. At all stages of proceedings, the defendant's behavior, manner, facial expressions, and emotional responses, or their absence of, combine to make an overall impression of the trier of fact, an impression that can have a powerful influence on the outcome of the trial. Demeanor is particularly important in capital trials when the defendant's life is at stake. Serious prejudice could result if the defendant's capacity to react and respond to proceedings and to demonstrate remorse or compassion is inhibited. Subtle indicators of ASD can be just as damning for capital defendants, if not more so. Inability to make and maintain eye contact is a common symptom of ASD, which can be mistakenly interpreted as guilt or shame. Due to their difficulty recognizing the emotions of others, people with ASD may make facial expressions that are awkward and incongruent with the tone of the proceedings. Most concerningly for capital defendants, people with ASD often display a flat affect. In fact, even in the face of highly emotional evidence, which can be interpreted as coldness or a lack of remorse. Mr. Kohberger's ASD manifests in many of these highly prejudicial but completely involuntary mannerisms. Dr. Orr observed that he subtly rocks his upper torso, especially while engaged in a cognitive task or listening to someone, both of which almost certain to occur during his trial. His range of facial expression is limited. His baseline affect is stoic, and his expressions are sometimes incongruent with what is happening around him. Mr. Kohberger also exhibits atypical eye contact, including an intense gaze. As discussed, facial expressions, including his lack of affect and concentration stare, are already being assigned sinister meaning by observers. Jurors begin assessing a case from the moment they step into the courtroom. In this case, when jurors will be forced to determine whether Mr. Kohberger will live or die, Mr. Kohberger himself is essentially a piece of evidence to be examined and evaluated. Every movement and expression is subject to analysis. Due to his ASD, Mr. Kohberger simply cannot comport himself in a manner that aligns with societal expectations of normalcy. This creates an unconscionable risk that he will be executed because of his disability rather than his culpability. People with ASD make poor witnesses. Concerns about the demeanor of a defendant with ASD apply with greater force when he chooses to take the stand in his own defense. Both verbal and nonverbal communication with the jury is impeded by the deficits experienced by someone with ASD, perhaps to an even greater degree than someone with an intellectual disability who may not experience the same level of social impairment. A person with ASD will struggle in the witness stand in a myriad of ways. Aside from atypical social behaviors, individuals with ASD may exhibit uncommon verbal or speaking patterns. Sometimes their phrasing is unusual, nonsensical, and exceedingly formal. They may take a long time to answer questions, which may appear evasive. They may also let out sudden and unexpected verbal utterances, which might come across as rude. They may also misinterpret or nitpick questions asked of them during questioning or cross-examination. For example, defendants may fail to pick up on cues which signal the end of a line of questioning and attempt to shift the conversation to a topic of their interest. Such behavior may be misunderstood as the defendant being cagey or unwilling to discuss a particular area or answer questions. As another example, when questioned in his jury trial, a defendant with ASD instigated arguments with the prosecutor over comparatively trivial details, while failing, unless redirected, to confront the underlying and critical question. Due to the deficits associated with ASD, a defendant like Mr. Kohberger is just as highly as someone with an intellectual disability to make a poor witness. Mr. Kohberger's speech is awkward, both in its content and delivery. As Dr. Orr observed, his tone and cadence are abnormal. His interactions lack fluidity, and his language is often over-inclusive, disorganized, highly repetitive, and oddly formal. He is highly distracted by sounds or activity occurring around him, and he frequently looks from side to monitor his periphery. As a result of his high distractibility, he often needs questions or instructions repeated. He frequently shifts the topic back to himself, even when it's inappropriate. He uses abrupt, matter-of-fact phrases that would be considered rude. He carries on about topics in a circular manner, and he perseverates. Oh my gosh, I can't even speak tonight. Vociferates about specific, non-essential details. These symptoms of Mr. Kohberger's ASD will alienate him from the jury and significantly hamper his ability to make a persuasive showing of innocence or of mitigation. It is well recognized by courts and scholars alike that evidence of ASD, like intellectual disability and youth, is a two-edged sword. The risk that the jury's fear about the defendant's future dangerousness will overshadow the mitigating force of defense evidence is especially pronounced in cases of ASD. ASD is beyond the comprehension of most jurors, and it is chronic, permanent, and untreatable. Research has found that neurotypical adults demonstrate negative implicit bias against adults with ASD. Moreover, and particularly relevant to Mr. Kohberger's case and the media frenzy surrounding it, heightened media attention on ASD-associated crimes has raised public alarm over the possible link between an autism diagnosis and violent behavior. Although there is little research on junior receptivity to ASD as mitigation evidence, studies have repeatedly found that jurors view evidence of serious mental illness as aggravating factors rather than mitigating. Several analyses demonstrate that although jurors believe in the abstract that mental health evidence will make them less likely impose death, in reality the evidence is often presented and discounted, presented and ignored, or presented, rejected, and treated as an aggravator. Even if the court does not find that a categorical exclusion is warranted, the lack of reliability inherent to any death sentence imposed upon Mr. Kohberger provides independent grounds to strike death in this case. There is no need to speculate about what impact Mr. Kohberger's ASD might have on his ability to present a meaningful defense. The prejudice is already clear. It is in its decision transferring venue of Mr. Kohberger's case, the Latah County Court acknowledged the extraordinary media attention received by this case. Much of that attention focuses on Mr. Kohberger himself, in particular on his disability. Outlets ranging from the New York Times to true crime video bloggers have assigned nefarious meaning to symptoms of Mr. Kohberger's ASD. Multiple news sources have, for example, focused on Mr. Kohberger's social deficits, particularly as they relate to his interactions with women. NBC News accused Mr. Kohberger of making creepy comments to female staff at a brewery. The New York Times ran an article alleging that Mr. Kohberger made female students at Washington State University feel uncomfortable, though an investigation by the university cleared Mr. Kohberger of any wrongdoing, and described how he lost his job as a teaching assistant due to his failure to meet the norms of professional behavior in his interactions with the faculty. If true, these allegations can easily be explained by Mr. Kohberger's ASD. Given their difficulty interpreting social cues, people with ASD may misconstrue social niceties as a romantic interest. It is also no surprise that Mr. Kohberger came across as socially awkward, or that he struggled to adapt to professional norms. These impairments are hallmarks of his disability. Lack of facial expressions and abnormalities in eye contact and body language are so emblematic of ASD that they are explicitly listed in the diagnostic criteria for the disorder. But to the online commentators who have developed a cottage industry devoted to parsing Mr. Kohberger's every movement, these symptoms of his disability are sure signs of his guilt. One video analyzing Mr. Kohberger's body language, which has received over 1 million views, infers guilt from his deadpan look and robot-like walk. Posting that his facial expressions and body language prove he is a murderous incel. Live now from Fox, Idaho murders what suspect Bryan Kohberger's body language tells us. YouTube, January 4th, 2023. A similar video viewed over 350,000 times lambasts Mr. Kohberger for his glare and blank empty stare, his cold iciness, his intense expression, and his lack of facial affect. Law and Crime Network, cold iciness, Bryan Kohberger's body language before and after arrest for Idaho murder analyzed. YouTube, May 23rd, 2023. Noting the rigidity of his posture and his apparent lack of emotion, the New York Post described Mr. Kohberger as showing a level of calm most comparable to infamous assassin Lee Harvey Oswald. Stephanie Pagones accused Idaho killer Bryan Kohberger's body language compared to Lee Harvey Oswald. New York Post, May 23rd, 2023. headline from the U.S. Sun says it all. Look of a killer. Idaho suspect Bryan Kohberger's psychopathic stare. Entering court hides chilling emotions, says body language expert G.P. Rodriguez, the U.S. Sun, January 3rd, 2023. The widely viewed and highly prejudicial media reports draped in the language of expertise and analysis demonize Mr. Kohberger for his disability. In an environment so tainted by rampant and vitriolic conjecture, it is impossible for Mr. Kohberger to receive the individualized sentencing determination, including full and careful consideration of mitigating evidence, that the Constitution demands whenever the state seeks to extinguish a human life. The sustained national media attention on this case also repeatedly emphasizes that the alleged crime is brutal and shocking in nature. These types of cases were a particular concern to the U.S. Supreme Court and underpinned the categorical approach in Atkins and Roper. Okay, let's go. Conclusion. No, let's go over here. There's little doubt that this reality will overpower any mitigating arguments based on ASD as a matter of course, amounting to an unconstitutional risk that Mr. Kohberger, on account of his disability, will be unreliably convicted and sentenced to death. For all of these reasons set forth above, Mr. Kohberger's ASD prevents him from being sentenced to death in a manner that accords with the constitutional requirements of proportionality and reliability. Like juveniles and people with disabilities, he is insufficiently culpable to be sentenced to death. The aims of deterrence and retribution will not be satisfied by his execution, and he faces an unacceptable risk that the death penalty will be imposed in spite of factors which may call for a less severe penalty. As such, the death penalty must be struck as a possible penalty in this case. I think, let me see where you guys are. Hi, everybody. So how's everybody doing? I think we're going to stop there. We'll continue tomorrow with that, and we'll do a word game to kind of clear our head before we go. I hope that you all got something out of that, and hopefully that was okay for you guys. What have you got? Kale? I've already got kale. Gleek? Gleek. No. I have all those, you guys. Okay, that's good. Hi, Victoria. How are you? We're just trying to finish this up to go to bed. I tried Geek, it doesn't work. Gala. I got one. Oh, what am I going to do? What do we got here for this last one? It's got to begin with a G, or an E, because it goes in alphabetical order. Oh, this is crazy. This is crazy. I know, this is crazy. There's no way it could be geek. It's not alphabetical order. Oh heck. It begins with an A. A-L. Oh my gosh. That's crazy. Wow. Having like a hurricane outside. All right, I think I'm just going to go to bed because that was a lot. So I'll see you guys. I love you guys. God bless. Prayers. Thank you for watching. We'll do more tomorrow. Thank you so much. Thank you. Bye-bye, guys.